All right, let's try this again. We were having problems with still are. I'll turn off the live chat. I was told that people were not doing very well. If you're gonna do that, watch something else. Anyway, we're gonna be busy and we're still struggling with our setup here, but I think we're good. All right, thank you for your patience, Ms. Castleman. Are you Margaret Ann Castleman?
Yes.
Yes. All right, you got a ticket for failing to stop after a collision. Let's take a look at your ticket. Did they get a verdict in that case yesterday? They're still deliberating? Yesterday, we had a group of students here from Centerville. We had jurors. And we had a very busy criminal day. Today, it's mostly just us here at district court, but they're still deliberating a verdict in the circuit court. All right, Ms. Castleman, you got a ticket in Constantine, but they wrote this under state law rather than village ordinance, or Mr. Bush could take care of it. It alleges that you were driving a Ford Fusion. They're recalling a bunch of those right now in the Constantine Middle School parking lot and collided with another vehicle. And then did fail to immediately stop and notify the other driver of the accident. That's commonly known as fail to stop after a collision. It's punishable by up to 90 days in jail, a fine of up to $100. The normal fine with costs is $225. Apparently they have some security footage. So how do you plead to that charge?
Guilty.
All right, did anyone threaten you to get you to plead to that?
No. I'm ashamed of myself for even taking this in the parking lot.
Well, sometimes when you do a dumb thing, the best thing to do is own it and get it over with. And,
It scared me because a year prior to that, I was in a car accident and the car rolled and I kind of had PTSD from that.
you had a flashback.
Yeah.
Well, it says you were at the Constantine School at about 1903, which would be 7 o'clock at night. Did you back into another car or something?
It was in the morning.
Oh, it said 1903. All right. Well, tell me what happened.
I went to pull around the horseshoe, and as I did, I took my eyes off of the parking lot just for a second, and I rammed into the car, and it scared me. There was nobody there. I should have went to the police station. All the people were gone because there was a wrestling meet that day out of town.
January 18th, was that a Saturday morning? Okay.
Yeah.
How much damage did it do to your car?
It didn't do anything to my car.
Well, it must have done.
It broke just the fog light off of the driver's side. That's all it did to my car.
All right. This doesn't carry a license suspension or anything. Doesn't look like you really have any problem with your license.
I had two of my grandkids in the car with me too, and it scared them too, of course.
Yeah. All right, the fine is $100. There's a $75 crime victims' rights fee and a $50 state minimum fee. There's no jail here. Can you pay that fine within 30 days?
I can pay it today.
All right, well, I'll just take you out there now. You can use a credit card or pay cash, but this will get it over with. We call this our bailiff exercise program. We have the court officers run the files back out to the desk for us, and that's helpful. All right, you can take you out there, he'll pay the fine. This matter's over and done with. This will put 2 points on your driving record, but you don't have any driving problems. Let me make sure you don't owe me any money. Nope. All right, good luck, ma'am.
Thank you.
Daniel Fry. You're tucked all the way on the inside. All right, let's talk about your case. This is file 25689 SM. Are you Daniel Lee Fry?
Yes, sir.
Mr. Fry, you're charged with the crime of the day, driving without insurance, driving with a suspended license, and improper plates. Those things often go together. You got $909 worth of previous unpaid tickets going back to 2021, allowing another to violate the motor vehicle code. Boy, you didn't pay any on that. Speeding, no proof of insurance, didn't pay that. No registration plate and another registration plate. So you got $909 worth of fines. You did say you wanted to come in today and pay some.
Yeah,
As a general rule, I said people don't go to jail for this, but for you, I could make an exception.
Oh, please
You
don't.
got a number of previous convictions for the same thing, and you don't pay your fines. So best bet may be to get a lawyer to help you with this. Do you have insurance now?
Yes, sir.
All right. Let's take a look and see why you're suspended. Probably because you got a bunch of unpaid tickets.
Been a long suspension.
Well, I call it getting on the driving suspended merry-go-round. Once you get on it, it's hard to get off it. You're actually revoked. And you and I go back a ways, but you got a lot of old baggage on your license. You must have, gosh. You and I go back a long ways.
Yeah.
I was still a prosecutor in the 80s. Anyway, you got some old drinking driving convictions, and then you got a bunch of driving suspended tickets. And you're not supposed to drive. In 2021, they cut you a break and reduced it to allowing another to violate the motor vehicle code, and you never paid the fine. Then you kept on driving and kept on driving with no insurance. So you do have insurance now?
Yes, sir. I actually done a lot of work on my license when I was in prison and got them back. And when I got out, they were expired. I was to renew them. They said I had a ticket to pay here. And I come and paid the ticket, and then they revoked them.
All right. I think you could use a lawyer to help you.
Yeah.
Are you still living on Clay Street?
No, sir. I live in Mottville now.
All right, that's officially out in the boondocks.
There was nothing there. The town just killed me.
Well, maybe now, the problem is when you live way out in the country like that, You need to drive. You can't drive. I don't know why you got revoked. When did you get out of prison?
It's 2016.
Well,
And I went to renew my license. And they said I had 2 tickets to pay here that I got in 2012.
well, there was a 2009. All right, I think you could use some legal help.
Okay.
I'm gonna appoint an attorney. Set an attorney pre-trial for the June date.
Do you want to see the proof of insurance?
I'll ask you to,
Today?
the clerks to make a copy of it.
Okay.
Please note new address. And copy his proof of insurance. How about registration?
I haven't got that yet. It's $120 and money's really hard to come by.
Well, it is. And the problem is you can't get registration or insurance if you don't have a valid license. So we're going to find out about why you're revoked and you need to stop driving. How'd you get here?
My daughter-in-law brought me.
Very good. Don't make things worse.
Right. The only reason I was driving that day is my brother-in-law passed away.
All right. Well,
I had to go to work.
all right. That happens a lot. People, their ride doesn't show up. They got to go to work or they lose their job. The person they thought they had a ride left without them,
Right.
or sometimes they're just plain old driving, but we'll get you a lawyer to help you with this.
Okay.
All right. Okay. I'll see you in June. They'll give you the date out there at the county. I'm not sure what the date is. I think it's June 13th. While we're doing this, Mr. Gabriel is also doing some pre-trials. I have one of those now. Victoria Palau. Did I say that right?
Yeah.
Ms. Palau, you got a ticket for driving without a valid license and also speeding. Speeding ticket is $90 and carries 2 points. Mr. Gabriel's agreed to dismiss the speeding ticket if you plead to driving with no valid license, sometimes called no ops. That's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100 plus costs. And just to tell everybody what costs are, is the state thinks everybody's rich. So they have a $50 state minimum fee and a $75 crime victims' rights fee. So everything carries $125 of money that goes to the state. Anyway, are you willing to acknowledge that on that day you were driving without a valid license?
Yes.
Do you have your license now?
And I'm still trying to get them.
All right. Well, you don't have an advice or right, so let's tell you and everybody else. When you plead guilty to an offense, you give up your right to have a trial. And that just seems to make sense. By pleading guilty, you give up their right to have a trial in front of a judge or jury. If you had a trial, you'd have the right to be represented by an attorney. Like the last gentleman, I appointed a lawyer for him. Or you could hire an attorney of your own choosing if you wish. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. You'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent. Your problem is Indiana, is that correct?
Yes,
All right. You live in Indiana?
I do.
Yes, all right, I'll show this as no ops ever, which might save you some points. I saw you at your arraignment, and we set this pretrial. We made a little progress. $100 fine, $125 of costs, $225. Can you pay that today, or do you need time to pay it?
I can pay first for my, can I see?
All right, I'll give you 30 days. Today is
You said
May
125?
$225. Make it due by June 15th. Now, you can pay with green cash, check or money order, credit card. Many people use a credit card. We don't take Bitcoin yet. But good morning, Mr. Cabry.
Morning, Your Honor.
Thanks for your help here. I got a few customers I'm generating for you also.
Well,
You can only do what you can do.
going next door and I'll be here and I'll be.
All right, thanks. All right, you're free to go, man.
Thank you.
Thank you. All right, we're inching along. Mariah Frazee. Frazier. That's not on me. They didn't spell your name right on here. Mariah Ray Lynn Frazier, that's you?
Yes, sir.
All right, let's talk about you. You fit right in with everybody else. You've got a no insurance and a registration plate charge. We got zillions of these. So let's take a look.
Keep in mind, if she's in the hospital, that she might be in there a few days, so maybe you want to go 3. It doesn't matter to me. Is everybody here on landlord tenant or what?
They're on Zoom, Your Honor.
I know, look at all these people in the courtroom. I don't even know what they're here for. Are these landlord tenant too?
They're all, it's all mixed in, Judge.
Okay. So whenever you see Gabe, you can tell him I'm ready on Zarate and Rodriguez.
Which Rodriguez? So I got a Jonathan Rodriguez down here.
Jaleesa.
Okay.
Somebody get those files. We're gonna need a date with Martinez to Lisa when I call that case, about 3 weeks out when Brownstown's here. W83355. Teresa Booker, have a seat at the table. My right, your left, please. Ma'am, your name?
Kevin Smith.
Well, you gotta show up. Where you been?
Been here.
This has been a year.
Yeah.
Why didn't you show up?
I went kind of straight into work.
I'm sorry?
Life's kind of kicking my behind. I was just going into work, trying to keep up with bills and.
You gotta show up in court though, okay?
Yeah.
You got it? How much do you have today?
Definitely learned my lesson.
How much do you have
I
today?
have $250 today.
Sir, you have to take your,
So you gotta take your hat off.
well, you only have one case here, right?
That one, yes.
Judge, she does have 2 other tickets. They're just not defaulted yet.
All right. You pay 185 on this case. I'll waive your balance, okay?
Appreciate that, Judge. Thank you.
So then you can go down and apply on the other ones, all right? Good luck. Next time, show up on
All
time.
right, if we're not coming back here.
Good,
Thank you.
good. Teresa Gale Booker, 25R514137. Booker? Where's Teresa Gale Booker?
She's on Zoom, Judge.
Okay. This is file 25R514137. Ms. Booker, you have to state your name, please. I don't have a. Looks like. Your name, ma'am?
Teresa Booker.
Can you figure this out, Lisa? It looks like we've only got an Ohio record in here or something.
I'm from Ohio.
Do you have a do you have a Michigan license?
No,
You live in Michigan though.
I live in Ohio.
Okay, all right. You used to live on Sycamore?
Right. In Trenton, Ohio.
All right. You're going to plead to impeding traffic, correct?
Yes.
To that charge, responsible or not responsible?
I'm sorry?
Responsible or not responsible to impeding traffic?
Responsible.
I'll accept the plea, dismiss the improper lane use, $225. Can you pay that today?
No, I get paid at 5 a.m. I
Okay,
can pay whatever then.
you can pay it tomorrow then. Go online, 33court.com with your case number and make your payment tomorrow, okay?
Okay.
Best of luck, 33court.com.
Okay. Thank you so much.
You're welcome. Good luck. All
Thanks.
right. This is,
Do you read it now?
Riverside. Give me 1 second. Oh, Riverside versus Amia Fisher, 2501671. All right.
Max, good mood on behalf of the plaintiff, Your Honor.
Good morning.
Good morning.
Is Ms. Fisher out there, please, or Jennifer?
She's coming.
She's on Zoom, Judge.
Do you know why?
Good morning,
Good morning, your name?
Amia Fisher.
Did you listen to and understand the rights on the video?
Yes, Your Honor.
Did you wish to speak to a lawyer?
No, Your Honor.
Have you applied or do you intend to apply for funding?
No, Your Honor. I don't need to apply for funding. I got laid off from work for about 3 weeks. And I'm back to work now, and I just recently made a big payment on my rent.
Counsel, why don't you tell me what the balance, I don't need a breakdown right now. Just tell me what the balance is, please.
Management indicates the balance at this time is $1,837.50.
Did you agree that that's what you owe, ma'am?
No, the balance is $2,039. They added on $179 for court fees. I checked it yesterday.
He just told me you owe $1,837.50. You should be representing them maybe. I don't know. Right? He
So
just told me, didn't you tell me $1,837.50 was the total balance owed?
That is correct, Your Honor. The issue that the tenant's addressing is the fact that it looks like the client added in the court cost twice to the ledger. That was incorrect, so I removed one of the charges of the court cost, bringing us to that $1,837.50. If the defendant would like to pay more than that, we're not going to fight with her. But at this time, I believe that the balance is $1,837.50.
Can you pay that?
Yes, I can pay that as soon as possible. I just got back to work.
Oh, wait a second, slow down. I can't, as soon as possible, you gotta give him a better date than that.
Okay.
I don't know what that means.
I'll be able to I get paid weekly. I'll be able to make.
Here, stop, listen, this is what I'm gonna do. I'm going on to another case. I'm gonna finish all of his cases, and then he's gonna go into a breakout room with you, and maybe you two can work something out. So just be patient. I'm gonna go through his other cases. As soon as I do, then, he'll go in a breakout room with you, okay? So just be patient. Riverside Townhomes versus Thomas and Allison Paquette. 2501674.
Max, field mood on behalf of the plaintiff, Your Honor.
Paquette. Good, thank you. Where's Thomas Paquette? I need you out here, sir. Allison Paquette,
He's connected now, Your Honor.
I need you to start your video, please. Your name?
Thomas Paquette,
Where is Allison?
right here.
Sir, Mr. Johnson, you have to take your hat off. Although I like the Tigers, you can't have that on in here, okay? Allison, where are you? Allison, state your name, ma'am.
Allison Paquette.
Did each of you, Mr. and Mrs. Paquette, listen to and understand the rights on the video?
Yes.
Yes.
Do either or both of you just and I'm going to ask you to speak first, sir. Do either or both of you wish to speak to a lawyer?
No.
Ma'am,
No.
have you applied or do you intend to apply for funding?
No, I'm gonna pay the rent.
All right, ma'am, have you?
No.
All right. How much is owed real quick? I need your appearance, counsel.
Max, Muda on behalf of plaintiff, Your Honor, we've got a balance on this one indicated by management in the amount of $2,946.
Do you just have Riverside Townhomes with me today?
I have Riverside Townhomes and South Point Square Apartments.
Yeah. Okay. When can you pay this, Mr. Paquette and Mrs. Paquette?
Well, I tried to pay my April's month today, but they locked me out of the account to where I can't pay it, and I've been trying to get a hold of them all morning. So I could have it paid by the end of the month.
You want to talk to him, Mr. Modar, or what do you want to do?
Your Honor, I'm fine with providing till the end of the month.
Okay. You want to do a conditional dismissal or a consent judgment?
So I've got a consent judgment with language in it indicating if paid timely, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. And so as long as they email me, once they get this properly taken care of, I'll be happy to set aside this judgment, dismiss the case. So I've got it set up as a consent judgment.
All right, let's slow down. Okay, so you're proposing a consent. I don't want to, I've got a lot of people here today. I don't want to be doing this on every case. So you guys are going to get to talk in a breakout room, but quickly, and you're going to have to figure it out. I'll pass this case. I'm moving on to another one. Okay, so stay there. We'll put you in a breakout room with Mr. Mudar when you're done. Okay, as soon as I get through some of these others. Riverside versus Tricia Wansowitz and Carson Wansowitz, file number 2501676. Ma'am, your name?
Trisha Wansavage.
Where's Mr. Wansowitz at?
Carson's my daughter, but she's not with me today.
Or she's a party to the action. She must have signed, right? She signed the agreement. So
she did, yeah.
She's got to appear here. State your appearance, give me the balance real quick, counsel.
Max Muda on behalf of plaintiff, Your Honor, the balance we've got here is $3,886.
Jesus.
You gonna pay that, ma'am, or what are you gonna do here?
So I was wondering if there was a way I could set something up because I am going to move out of there. Like I want to leave. But if I can have time to pay it, just so it doesn't go on our credit as an eviction, if there's a way we could set something up.
I'm going to let you two talk here momentarily. That would be a default against Carson Wansowitz, Mr. Mudar. So I'm going to let you two talk. Just be patient, Ms. Wansowitz. He's got some other cases to get through, and as soon as he does, I will we'll put you in a breakout room with him. Okay, so just wait 1 second. I'll be with you in a minute. Riverside versus Brendan and Cheyenne Adams, 2501678. Mr. Adams, your name?
My name's Brendan Adams, Your Honor.
Where's Cheyenne Adams at?
She is at home, sir.
Okay, they have to show up though, that she's going to be in default.
Oh.
Mr. Mudar, your appearance?
Max Muda on behalf of plaintiff, Your Honor, the balance that we've got on this one being $1,419.51.
All right, I'm going to let you two go into a breakout room as well. Just remember that she would have to be defaulted if you guys reach an agreement. Okay, I'm going to pass all those. I'm going to go on to South Point. As soon as I'm done with those, we'll put you in a breakout room with those individuals. South Point versus David Carter, 01664. Mr. Carter, your name?
Yes, Your Honor, David Carter.
Did you listen to and understand the rights on the video?
Yes, Your Honor.
Do you wish to speak to a lawyer?
Well, no, I do not wish to speak to a lawyer.
Have you, or are you intending to apply for funding?
I am, right, Your Honor, right now I'm in the process of waiting. I'm going to be reinstated. I work for Ford Motor Company, the UAW.
I just asked if you're applying for funding, that's all. Are you not applying for funding? No intent to apply for funding?
Am I applying for funding? No, I'm not applying for funding.
All right, counsel, your appearance and what is the balance?
Max Mood on behalf of plaintiff, Your Honor, with a balance of $1,588.56.
I'm gonna let you two go into a breakout room. You can see if you resolve it. Just be patient, Mr. Carter. He'll be with you momentarily, but he has a few ahead of you, okay?
Thank
South
you,
Point
sir.
versus Robert Johnson, 2501665. Mr. Johnson, your name? You got to unmute, sir.
Oh, Robert Johnson.
Mr. Johnson, did you listen to and understand the rights on the video?
I did, Your Honor.
You wish to speak to a lawyer?
No, Your Honor.
You intend to apply for funding?
I wasn't gonna. I have 900 that I could put towards it tomorrow, but maybe in the future I could apply for additional help.
But as of this moment, you have no intention to apply for funding?
Not right now.
Counsel, what's the balance after your appearance?
Max Mood on behalf of plaintiff, Your Honor, we've got a balance on this one in the amount of $1,952.85.
I'm going to let you two go into a breakout room and speak on these, and I will then come back to you. So just be patient, Mr. Johnson. He has a few ahead of you, and he'll be with you momentarily, all right?
Thank you, sir.
South Point versus Tierra Matthews and Eli Moulton Jr., 2501667. Good morning, ma'am. Your name?
Good morning, Tierra Matthews.
Is Mr. Moulton? Yes, you are. Sir, you have to take your hat off. State your name.
Good morning. My name is Eli Moulton.
All right. Did you listen to and understand the rights on the video, Ms. Matthews?
Yes, sir.
Mr. Moulton?
Yes, sir.
Do you wish to apply? Wait, I'm sorry. Do either one of you, and I'm going to ask you first, ma'am, wish to speak to a lawyer?
No.
Sir?
No.
Do either one of you intend to apply for funding, ma'am?
I tried to already, which that didn't go through. I am gonna try and see if I could reapply for any assistance though.
When did you apply?
I would say maybe about 3 weeks ago.
And they denied you?
Yeah.
So why do you think they're going to give you funding now?
I'm not sure. I'm just gonna attempt to try again and let them know the changes that has been made and just.
All right. Okay. Here's what I'll do. I'm going to adjourn this 2 weeks. Defendant to submit application for funding. I'm talking about from one going forward now within 5 days to the court. Okay. I'll adjourn this 2 weeks until May the what?
29th, Your Honor, at 1 o'clock.
At 1 o'clock, okay? So that's what I'm going to do. So you have to apply for funding, and I'm not talking about the prior application, a new application, and submit that to the court within 5 days. And then the two of you have to be back here on May the 29th at 1 p.m., okay?
It will
Any
be the
questions, Ms.
same
Matthews?
ID.
I'm sorry, yes, same Zoom ID. Any questions, Mr. Moulton?
No questions, nope.
All right, good luck, folks. Thanks.
Thank you. Have a
South
good day.
Point versus Kyla Moreno and Robert Mendoza, 2501668. Are they here?
Robert Mendoza is here.
Yep. Okay, there you are, sir. Your name, please?
Robert Mendoza.
All right. Is Kyla Moreno here?
She's not, sir. She's at work. They don't let you use the phone.
I'm sorry, I didn't hear you.
She's at work and they don't let you use the phones. So
where is she?
She's at work and they don't let her use the phone at work, Your Honor.
All right, she has to be here then, sir. So I'm just telling you, she's going to be in default. Did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
Do you intend to apply for funding?
No, sir.
What's the balance, counsel? I need your appearance too. Max Fieldwood on behalf of plaintiff, Your Honor. The balance that we've got on this one is $1,929.84.
All right, I'm gonna let you go into a breakout room with him momentarily and you can speak to him, okay? And see if you can resolve something, Mr. Mendoza. Remember, she would have to be a default if there's a resolution reached. South Point versus Diana Ostowski, 205-01-669.
Your Honor, Ms. Ostowski did not appear this morning on Zoom.
Counsel, you paid for a second mailing, true?
That is correct, Your Honor.
Go ahead, I'll be glad to give you a default.
At this time, plaintiff moves for the entry of a default judgment. This is a non-payment case for possession only. We've got a rent to retain being $3,011.77. Court costs $179, giving us our grand total here today of $3,190.77 with a writ date of May 27th, 2025.
All right, just make sure, May 27th, you said?
That is correct, Your Honor.
Just make sure you send that judgment over today, please, okay?
Will do, Your Honor.
All right, so the amount to be paid to save it is $3,190.77. Defendants in default. Writ date will be May the 27th of 25. South Point versus Romantic Smith. Romantic Smith, 250-1670.
Your Honor, the defendant is not here, but Alan Smith, an occupant, is present.
You can state your name, Mr. Smith.
Yes, Your Honor, Alan Smith. Good morning.
Oh, okay, so he's not on counsel, your appearance?
Maxfield Muda on behalf of plaintiff, Your Honor. We've got a balance on this one being $2,742 and 83 cents.
274283?
Correct.
Sir,
Yeah,
you're not on the lease, right?
I'm an occupant on the lease.
Did you listen to and understand the rights on
Yes,
the video?
yes, Your Honor.
Do you wish to speak
Yes,
to
Your
a
Honor.
lawyer?
No, I'm just going to pay it. He opted out on the lease, so I might need to talk to a lawyer to follow up to find out what steps to take after paying the rent, because I don't have nowhere to go. I don't know where my son went to, but I don't have nowhere to go, and I can pay the rent.
Okay, so you're not applying for funding.
No.
All right, I'm gonna let you two go into a breakout room here momentarily and speak on this, okay? So, counsel, you can go in. Do you need me to tell you the cases, Jennifer? It's pretty much all of them. I'm gonna send them in there.
Yes,
Thank you.
we're all set. He's got access and we've got rooms 8 through 15 for him.
Good, thank you.
Your Honor, I believe I've got one that wasn't called.
Which one's that?
Case ending 1673, Riverside versus Seamus Hancock.
Defendant did not appear on that one, Your Honor.
Riverside versus, you said Acock?
Seamus Hancock, Your Honor.
I don't have that file. Riverside versus Seamus Hancock. I do not have that one down here,
Okay.
Jennifer.
We'll get it all squared away for when he comes back in. It's a no-show.
Thank you.
Thank you.
All right. Raymond Charles Gordon, 25F243-947A and B. Mr. Serrano, why don't you tell my court officer what you have? Sir, your name?
Raymond Gordon.
You're charged with driving on a suspended and invalid registration, a civil infraction, that charges. You have the right to a lawyer for arraignment. If you want one, tell me, I'll give you one. If you don't, then I'm going to arraign you. That is, explain the charge and the possible penalties. I'm going to send you to talk to the prosecutor. Okay? You can go out in the hallway and we'll set you up with an attorney, okay? Jeremiah Mitchell Davis, 25F243-817. Your name, sir?
Jeremiah Davis.
You're charged with child neglect. And you have the right to a lawyer on this if you want one. Would you like a lawyer?
Yes, sir.
Okay. You go out in the hallway, we'll set you up with a lawyer, and then either way, you're coming back in front of me, okay?
Which way do I go?
Right
Yes,
out-
in the hall.
Yeah, out in the hallway there.
Thank you.
He needs a lawyer.
Both of them.
This one too?
No, these two. Jamie Allen Sywarski, 216R5095098.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf with my client, Chris, to my right. Your Honor, this being the date.
Your name, sir?
Jamie Zaworski.
Let's talk about where he's been first. This is 2016. This was only 9 years ago.
Yes.
What have you been doing for 9 years there, young man?
Trying to get it together, sir.
Trying to get it together.
Your Honor, this is our last stop. I've taken care of 4 matters for my client. They're all older cases.
While you're trying to get it together, you need to remember that you do not ignore courts like this, okay?
Yes, Your Honor.
If you can find this, any judge that will find this endearing, let me know who he or she is. Will you please? You can write me a note and say the judge in Lexington thought it was okay. I showed up 9 years late. All right? I want to know who it is. I want to call him up and say, how do you manage to keep your patients over nonsense like that? He's going to plead guilty, it says, to allowing an unlicensed driver to drive, right, Mr. Serrano?
That's correct, Your Honor. I've had the opportunity to explain to him what the nature of that charge is. He understands that. He understands the possible consequences be from this court or any administrative agency. We advise of rights. He has signed a form regarding that, and we're ready for the court's examination.
Sir, if you plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs or all of those. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights form today and read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
To the charge allowing an unlicensed driver to drive, how do you plead?
Guilty, Your Honor.
Were you in control of a 2001 Mercury that was being operated on I-75 near Huron River Drive in the city of Rockwood?
Yes, Your Honor.
And that was on July the 30th of 16, correct?
Yes, Your Honor.
And were you suspended, revoked, or unlicensed at the time?
Unlicensed at the time.
Are you on probation?
No, Your Honor.
Parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it. I'll dismiss the suspend. Go ahead. Anything, Mr. Serrano?
Your Honor, briefly for elocution, as I stated, this is my client's last stop. He in fact has an appointment with the Secretary of State to get a temporary permit. He has to retest, he has to road test again, but other than that, he's eligible, Your Honor. We've resolved all those other matters. And I believe Your Honor will show that he does have a $3,000 10% bond posted with this court. So we're asking for immediate sentencing, Your Honor. He will be paying the balance tomorrow. Is that correct? Yes.
100 fine. Anything you want to say?
I just wanted to take my time to apologize to you and people of the court for delaying.
You don't need to apologize to me, but you need 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4, 90 days. He has 3,000, 10%. By law, we keep 10%. You have 270 to apply. I don't even know if I want to give you time to pay. You haven't been here in 9 years. Did you hear what I said?
Yes, Your Honor.
It's ridiculous.
He'll pay, he lives in Brooklyn, Your Honor. He'll pay online tomorrow or if the court pleases.
270 now, you go down, sign your bond over, and then I want to make sure that's in his name. Yes, it is. And then you pay the rest by tomorrow, which will be an additional $155, okay?
155 due, Your Honor?
Tomorrow.
Yes.
Correct.
Thank you very much.
Have a good day. Good to see you, Mr. Serrano.
Always good to see the court, Your Honor. Thank you very much.
Thank you. Thanks. Thanks.
Can we go to the window then?
Oh, yeah. Thank you. Okay. Can I have Ashley Moore? For Andrea, my up on cause date. Have it all? 195.
Oh, I thought it was 1.
Well, you're late. You can't get a
I thought it
ticket.
was at 9:15 and I called.
When you didn't show up, this was from January. Okay?
I understand.
Can you pay anything more?
Tomorrow.
Can you pay anything more?
More than the 125?
Yeah, today.
Sure. I'll figure it out.
How much?
You said it's 195?
Correct.
I can borrow it from somebody for tomorrow.
I'm asking you if you can pay it now.
Yes, I said I'm gonna borrow.
I'm sorry?
I'm gonna call and borrow someone I can.
You pay 155 now, balance I'll waive, okay?
Okay, thank you.
All right, stop doing that. Good luck.
Thank you.
Thank you. People against Gardner. Jesse Lorraine Gardner, 25E147705. Same with you. Your name? Why aren't you showing up on time? How much do you have today? You have 198?
Yes.
Pay 179 now. I'll waive the balance. Not that you deserve for me to.
I don't have anything to do.
I thought, I just asked how much you had.
I thought you asked how much I owe. I'm waiting, I graduated in August, that's really what I was waiting for, but so when I got pulled over,
Wait a minute, slow down.
so.
Slow down. Slow down. I don't want to know about when you got pulled over. You didn't show up and you lost.
Right.
So you might have been the most innocent person in the world, but you went into default.
Mhm.
Okay?
Yeah.
Okay, so I'm not going to hear the case again. All right? I thought you said you had 175 now. You didn't say that? How much do you have now?
Nothing, I need a payment because I graduated in August, I have nothing until then. Because I can't,
Tell me how much you can pay and when.
I can make a payment on the 23rd. On the 23rd.
All right, you pay $100 by May the 23rd. When can you pay the rest?
June 6th, is 2 weeks from now.
Is that a Friday, Lisa?
June 6th.
Yes.
Sorry, I couldn't hear. Yeah, it's a Friday.
So you pay 100 by May 23rd and the balance by June 6th. If you don't have the money on any occasion, you call the court, we'll go on Zoom. I'll be glad to give you an extension. Just don't ignore me, okay? All right, good luck. Andrea Rich. Andrea Danielle Rich, 25F243816. Your name?
Andrea Rich.
You're charged with operating while intoxicated, and you have the right to a lawyer. I'll be happy to provide you with one today. Would you like one?
Yes, Your
Okay, I'll set you up with one. You go out in the hallway, and he will set you up with an attorney. Where's your other files at, Mr. Which one? Which one again?
Joseph Kimes and Rosa Martinez, Your Honor.
Yeah, I got it.
They have indicated that.
Oh, Joseph Matthew Kimes.
Ready.
25G306319. All right, appearance?
Greg Boulahanis, P36431. On
Sir.
behalf of Joseph Kimes.
Sir, your name?
Joseph Kimes, Your Honor.
You're looking awful sharp there, Mr. Kimes. It's nice to see somebody coming dressed up. He's going to plead to impaired with super drunk to be dismissed, true?
Correct, Your Honor.
Is that what you want to do, Mr. Kimes?
Yes, Your Honor.
If you plead guilty here to that, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all of those. 4 points, license suspension or revocation, excuse me, in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, to the charge operating while impaired, how do you plead?
Guilty.
On March the 2nd of 25 at 2:07 in the morning, were you operating a motor vehicle on North Gibraltar, near Gibraltar Road in the city of Gibraltar?
Yes, Your Honor.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, Your Honor.
Be honest with me.
Shots.
How many shots?
Probably like 7.
What else?
It was mostly shots.
What else?
Your Honor, I was on a party bus, to be honest with you. So I was.
So they were being hand poured.
Yeah,
right?
you're working in a bar, Your Honor.
Right, so they were being hand poured, and you're sure that there were the 7 shots, that there were maybe not double shots in there?
It's not
that you were furnishing alcohol to a minor and also furnishing tobacco to a minor. Those are both misdemeanors punishable by up to 90 days jail. Do you understand that?
Yes, I do.
All right. Did you sign an advice of rights form today?
Yes, I did.
Did you read it and understand it?
Yes, I did.
If you plead guilty, at any time, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, I do.
So do you still wish to waive your right to a lawyer?
Can I change my mind?
Sure.
Yeah, I do want a lawyer.
I'll enter a not guilty plea for you. We'll set it for a pretrial.
Your Honor, excuse me. Can I like settle the matter today? I'm prepared to pay.
Well,
fine or.
You're entitled to a lawyer at arraignment, okay? Listen, I just arraigned. You told me you didn't want one at first. Now, going forward, I need to make sure that you are considered indigent.
Well, I am guilty, sir.
Just hear me out a second.
Okay.
Going forward, I need to make sure you're indigent if I'm going to give you a lawyer. How much do you make in that employment there?
$400,000.
Are you an owner or are you an employee?
I'm just an employee.
How many hours do you work?
25 to 30.
How much do you get paid per hour?
Like a salary.
25 up to 30 hours, they pay you $400?
Sometimes less hours, yeah.
All right.
I just help out my cousin. My cousin owns the store and.
All right.
Salary.
Here, I'll give you a lawyer. I'll let the lawyer go in and negotiate for you, okay?
Thank you.
So you can go out in the hallway. We'll set you up with an attorney. Either way, you're coming back in front of me, okay?
Okay.
Good luck. Johnson Glover, Julian Enrique Johnson Glover, 25F243480. So we're running a little late here, folks, on these. Do I have more? Are they ready on any of those out of Riverside or Jennifer?
He's still going through them. The only other one I have ready is David Cassar at 9:00.
Your name, sir?
Julian Johnson Glover.
You're charged with operating while intoxicated. You have the right to a lawyer. Do you want a lawyer?
Yes.
Okay, I'll set you up with a lawyer. You can go out in the hallway, talk to them, and then either way, you're coming back in front of me, okay?
All right, thank you.
You're welcome. Al-Shami. Amin Hamoud Ahmed Al-Shami, 25R514112. Could I also have seated up here Eric Kosh, seated at the table? Eric Kosh, Koschhe. Your name, sir?
Good morning. My name is Amin Al-Shami.
You're charged with furnishing tobacco to a minor. You have the right to a lawyer. Do you want one?
No.
It is alleged that this occurred at 22430 Huron River Drive in Rockwood, April 19 of 25 at 8:08 p.m. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights form?
Yes, sir.
If you plead guilty, at any time, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, sir.
All right, you have the right. You still wish to waive your right to a lawyer?
Guilty.
You still wish to waive your right to a lawyer? Let's slow down. Do you still wish to waive your right to a lawyer? Yes? Okay. I'm going to enter a not guilty plea. Pardon?
Yeah, I'm not guilty. I'm guilty. I'm sorry. I'm guilty.
Just slow down.
Yeah.
I'm a judge, not a priest. Relax. I'm going to send you to the prosecutor. I'm going to let you talk to the prosecutor. Maybe he'll offer you something, okay? All right?
All right.
So I'm entering a not guilty plea, personal bond. You go out in the hallway and they will set you up with the prosecutor, okay?
Thank you.
You're welcome. Thanks. David Kasser. David Kasser. This is David Kasser versus Richard Kowalski. 2501-702. Mr. Kasser, your appearance? Yep, you have to unmute. Yeah, I know. One's going to an attorney, one's going to prosecutor. Mr. Kasser, your appearance? I can't hear you.
I am David Kassar, Your Honor.
Mr. Kowalski, your name?
Richard Kowalski.
Mr. Kowalski, did you listen to and understand the rights on the video?
I did, sir.
Wish to speak to a lawyer?
No, sir.
You intend to apply for funding?
I did, sir.
When did you apply for funding?
About a week and a half ago.
All right.
through the Michigan 411.
Here's what I'm doing. I'm adjourning this 2 weeks. Defendant to provide proof. This is what you have to do now. You have to provide proof that you've applied for funding with the court. So you have to come up here and bring it up to the court within 5 days. Within 5 days. Do you understand that?
I do, Your Honor, but it was all by over the phone, and she said there was no funding available for me because I'm 52.
Okay, well, then you're not applying for funding.
But no, there's no.
Wait a minute. I didn't hear you, sir.
The woman I spoke on the phone said there was no option for funding for me.
Okay. So you're not applying for funding then?
No. I tried. I looked into it, but there was no funding available.
All right. Mr. Kessler, why don't you tell me how much is owed on this?
Your Honor, this is a termination case.
Oh, geez, I'm sorry.
That's okay. That's my fault. I should have mentioned it. But it's a termination case, and there's no lease involved.
Why don't you have to move out, Mr. Kowalski?
Excuse me, sir?
I said, why don't you have to move out?
I do have to move out, but I don't have the funding right now, and I'll be homeless. So I'm just trying to buy time until I get my check.
I got to be able to pick you up. I don't know what's going on here. You're going to have to start over. You've frozen on the screen here. So, can you hear me, Mr. Kowalski? Oh, boy. Jennifer, any ideas?
Looks like he just disconnected, so he must be having internet issues.
All right, well, chat with him and tell him he needs to come up here.
Oh, wait, he's back. Let's see if
Okay.
Mr. Kowalski, can you hear us?
Mr. Kowalski, can you hear us?
Maybe I could call him on the phone. On another phone.
Why don't you do that? And you can tell him that the judge would like him to come up to court. Because it's pretty clear we're not going to be able to do this by Zoom with him. So you go ahead and do that, mute yourself. I'll go on to another case and we'll go from there, please, okay?
Your Honor, I can hear you now.
All right, Mr. Kowalski.
Your Honor, I can hear you now.
All right, good enough. Mr. Kowalski, why don't you have to move out of the property?
I do have to move out. I'm paid rent. It's not intentional. I was off work due to an injury. And then when I got back to work, it was too late.
Okay. What do you want to do here, Mr. Kessler? You want a 10-day writ or what do you want to do?
Maybe we can give him 2 weeks, Your Honor.
Till the what day? The 29th?
The 29th is fine. That would be great.
All right, Mr. Kowalski, I'm going to go ahead and indicate, and I'm going to fill out this judgment. The plaintiff has a right to possession of the property. I'm going to extend the writ date until May the 29th. If you're not out by then, he's going to submit an application for a writ, and I'm going to sign it. Okay? No money judgment is entered. Acceptance of partial payment will not prevent the court from issuing an order. Not that there is any payment to be made. Defendant may be liable for money damage after moving if additional rent is due, or if there's damage to the property. So you have to be out, sir, by May the 29th. If you're not, then he's going to make an application. For a writ. I'm going to sign it and you're going to be evicted, okay?
I will be out by the 29th, sir.
Good luck to you. I wish you well. Thank you. I filled out the judgment, Lisa, in here, or Jennifer, rather. You can send it out. Thanks.
Thank you.
Thank you.
Well. Bye-bye. Thank you.
Eric Allen Kosh.
Yes, Your Honor.
This is 25F243818. Good morning. How are you?
Good morning. How are you? I'm fine.
Good. Your appearance?
Your Honor, I'm here. Sean Mansour on behalf of the defendant. P number is 78438. Thank you for allowing me to appear by Zoom, Your Honor. Today's time and date set for an arraignment/pretrial in this matter. And just so the court's aware, we're just going to be asking for a quick adjournment for discovery, Your Honor. And we can also handle the arraignment, of course.
Mr. Kosh, your name again, please?
Eric A. Koshi.
All right, so he stands mute, waives formal reading?
That is correct, Your Honor.
Does he have any priors?
Absolutely not, Your Honor. He's 60 years old. He's a member of the community. He's gainfully employed. No priors at all. It's his first ever criminal offense.
All right, $500 personal bond. I'll enter a not guilty plea. Sir, you're not to purchase, possess, or consume alcohol, marijuana, or illegal controlled substances. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to give you a pretrial date in this case. When will that be, Lisa?
29th at 8:30.
Is that good? May 29th at 8:30?
It is, and we'll be in person, Your Honor.
Okay, great. I'll make a note in person. All right, we'll see you here then. Anything else, counsel?
Just one more thing, Your Honor. He has a pre-planned trip. Oh, I'm sorry. You said May 28th, right?
May 29th.
Okay. Mr. Koshi, you're going out of town May 29th to the 31st. Is that correct?
I was going to see my mother, yes.
When are you leaving?
May 29th, Your Honor.
Give me 2 seconds. So I feel like it was the 20.
I have your itinerary here.
Flying the 29th, coming back on the.
I know, I get it. What time on the 29th are you leaving? You leaving at 6 in the morning or are you leaving at 5 at night?
No, it's 7:30 a.m. flight.
All right, well, we'll do it another day then. Lisa, give me another day, please. Where are you going? Is that out of state?
Yes, it
Yes,
is.
I'm going to visit my mother, who's in a memory care unit on Martha's
So you
Vineyard.
should go visit your mother. Can leave state to go where, counsel?
All right, so we have Massachusetts. Is that the layover, Mr. Koshi? In Boston, I imagine, because you're landing in New York eventually, correct?
So on the 29th, I'm flying from Detroit to LaGuardia to Martha's Vineyard.
Okay. Your Honor, I don't mind either doing the 28th or if you want to push it out to the following week, I'm also available.
I don't do I can't do it the 28th. We only have the prosecutor here once a week.
Okay.
So give me another date, Lisa. You can leave the state to go to New York / Martha's Vineyard between May 29th and May 31. No alcohol, no marijuana, no illegal drugs. And we'll give you a new date, and that will be on what, Lisa?
June 12th at 8:30.
June the 12th at 8:30. You good then?
I'll make that work, Your Honor, Mr. Koshi.
Okay. June 12th, 8:30. We'll see you guys here at the courthouse. Have a great day. Good luck.
Thank you.
Thanks.
Thank you.
Goix, Ada,
It's okay.
Keckreler, sorry, 25F243909. Ma'am, your name?
Ada Chakrilash.
I'm sorry?
Ada Chakrilash.
Okay. All right, you're charged with drive while license expired. You have the right to a lawyer. If you want one, I'll give you one.
Yes.
Okay. Go out in the hallway. We'll set you up with a lawyer, okay? Thompson. Sir, you can leave if you want, Mr. Kosh. You're all set. Tricia Ray Thompson, 25R514-108A. And B and C. Your name?
Tricia Thompson.
You have 3 charges: furnishing alcohol to a minor. You have the right to a lawyer. Do you want one?
Yes, please, Your Honor.
Okay. You go out in the hallway. We'll set you up with a lawyer, and you'll come back in and see me whenever you're done. Okay? Here's another one for a lawyer. Curtis Hamadi. Curtis Brent Hamadi, 25R513-926A and B. Your name, sir? You're charged with operating while intoxicated and resist, hinder, and obstruct an officer. You want a lawyer? Okay, we'll set you up with the lawyer. Go out in the hallway, we'll set you up. You're all set. Caitlin May Lee Busby. 25F243696. Your name?
Caitlin Busby.
This is a misdemeanor noise violation. It says you didn't show up. Why weren't you here May 1st?
I didn't know I had, well, I did, but I just, it was.
I don't know what you mean by that. You forgot?
Yeah, the day of, what time?
You gotta show up in court, okay? This is important, right?
That's right.
You have the right to a lawyer. Do you want one?
Yes.
Okay, we'll set you up with a lawyer. It's gonna be a while, so just take your time, go out in the hallway, and as soon as they can get to you, they will, but we have a lot of cases in here. All right? Anaya. Jessica Lynn Anaya, 25R514118A and B. Providing tobacco, furnishing alcohol to a minor. Your name, ma'am? Do you want a lawyer?
Yes.
All right, you go out in the hall, we'll give you a lawyer, okay? Everybody wants to know.
Do you want a lawyer too?
Yeah. Right, so we'll see both of those. All right. Rodriguez, Jonathan James Rodriguez, 25F243935. And I'd like Alter up here. April Alter seated at the table, my right, your left. Ma'am, or sir, your name?
Jonathan Rodriguez.
You're charged with driving on a suspended. You have the right to a lawyer. Do you want one?
Is it advised I get one?
It's up to you. It's up to you.
I'm hoping at least to be able to plead my case, but I don't think it's necessary in this situation. Unless, like I said, you advise it.
It's up to you. Whatever you want. If you want a lawyer, I'm going to give you one.
I don't think I need one.
All right. Well, if you change your mind, you can tell me. On May 2nd of 25 at 7:35 p.m., it is alleged that you did operate a motor vehicle in Freeland or Telegraph in Flat Rock, and they think you had a suspended license, a misdemeanor punishable by up to 500 fines, 93 days jail, costs of all those and 2 points. Do you understand that?
Yes,
Hang on. Do you understand that?
I do.
And did you sign the advice of rights?
Was that paper?
Yes, sir.
Yeah, I read over it. Still, sorry. Yes.
Did you read?
Yes.
Did you understand?
Yeah.
If you plead guilty, you'll be giving up all those rights and will not have a trial of any kind. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yeah.
I'm going to enter a not guilty plea. I'm going to let you go talk to the prosecutor, okay? Personal bond, $500, and you can go talk to the prosecutor. We're going to bring the file to the Flat Rock prosecutor. You cannot, here's your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes, the bond more or less means.
You don't have to post any money. It means you're going to have to pay $500 if you violate any of those bond conditions though, okay?
Okay.
You're going to go talk to the prosecutor right now.
Okay. They'll answer my questions.
What kind of questions? Well, tell me what questions you have. They're on the other side.
Sorry, I'm still a little new at this. I'm still figuring out.
Okay.
I don't plan on being a career offender by any means. I was door dashing when I had gotten.
You shouldn't talk about that.
Sorry.
I just want to answer any questions you have.
As far as the 500 goes,
It's a personal bond. You don't have to post any money.
Okay.
You do not have to post any money.
All right, and then do I have a time limit to pay that? And then, sorry.
I haven't fined you. You haven't even been convicted of anything.
Okay.
Okay?
Yes.
So I'm going to send you to the prosecutor and see what you can work out with him. He's very reasonable usually. Okay?
Thank you.
And I hope he'll offer you something. And then we'll talk about how much money you have to pay if you're convicted of something. Okay? All right? Do you have any other questions? But you don't owe any money right now. You haven't been convicted of anything.
Okay.
Okay? You look confused.
I'm just new to all this.
All right, well, I want to answer your question so you're not confused.
Okay. Well, I don't even know how I would go about taking the case. When they told me I had this suspended, that was news to me. I just found out. So I'm doing what I can do to get my ducks in a row. But from my understanding, the prosecutor will help me assist a game plan or something.
Well, he's on the other side. He'll go over your record with you, and you can explain everything to him, and hopefully he'll be reasonable, which he always is, frankly.
I greatly appreciate it.
Okay?
Thank you for your time, Your Honor.
No worries. This is what I do.
Really, I am. I was nervous. But
just relax.
Talking about it just helps.
Good.
Here to do what I can do.
Good luck. We'll see you in a few minutes.
Go over to the
You go right over it out there, and he's going to take your file to the prosecutor, and you'll talk to him. Okay? All right. You're welcome. FC Stratford LLC. This is FC Stratford LLC versus let me see here. Hannah Love, and I don't know if that's a typo, but it says Dawid, D-A-W-I-D, Rebis, 2501554. Are you Ms. Love? Okay. Is Ms. Love here, or is it?
Your Honor, I have not had either defendant check in on Zoom.
All right. Good morning, Mr. Splain. How are you?
Your Honor, good morning. Mark Splain appearing on behalf of the plaintiff, FC Stratford LLC.
So Hannah Love failed to appear. Mr. Rebes was here. He said he listened to and understood the rights, had not applied for funding. I adjourned it a week. They're not here. You can go ahead and take a default.
I would love a default, Your Honor.
Okay, go ahead.
The rent to retain possession is $5,423.38. There are costs of $229.18 for a total of $5,652.56. Box 4A is checked. We can apply for writ after May 27th. Boxes 5, 6, and 7 are checked, and we will submit that if you'll accept it.
Defendant failed to appear. Default judgment center. The writ date will be on the 27th of May. It's the day after Memorial Day. And the amount to be paid to save it is $5,652.56.
That is correct, Your Honor.
FC Stratford versus Giovanna Perkins, 2501555. All right. Is Giovanna Perkins here? Yes, she is. Your name, ma'am?
Giovanna Perkins, I am here.
You have to start your video, please. Okay. Counsel, your appearance?
Good morning, Mark Splain appearing on behalf of the plaintiff.
Did she pay the amount that she said she could pay by May the 7th? Did she pay this amount due and owing?
Nothing has been paid. We're going to enter a consent judgment for possession.
Go ahead.
Your Honor, at this time, we ask for the consent judgment. The amount owed, rent to retain possession is $5,708. There are costs associated with this of $189.79 for a total of $5,897.79.
All right. Tell me the terms of the consent judgment.
The terms of consent judgment are we won't apply for a writ of eviction until June 15th.
All right. So, ma'am, do you understand that and agree to those terms?
Yes, Your Honor.
So you understand that a judgment will enter against you by consent today in the amount of $5,897.79 with the understanding that the writ date they're extending all the way to June 15th. Do you understand that?
Yes, Your Honor.
You agree to that?
Yes, Your Honor.
If you pay by then, you can stay. If you don't, you have to leave. Do you understand that? And if you don't, you're going to be evicted. Do you understand that?
Yes, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You also have 10 days to appeal this. Do you understand that?
Yes, Your Honor.
Does he have your permission to sign your name to that consent judgment?
Yes, Your
Do you have any questions at all for me, ma'am?
Honor. No, Your Honor.
All right. I wish you well. Good luck. You're all set. Thank you very much. Have a good day. Good luck, ma'am. Thanks, Mr. Splain.
Okay.
Do you have others, Mr. Splain? April Marie Alther, 24T640530, 24T640562. Good morning. Your name? Did you go and talk to the prosecutor today?
No, sir, I'm not.
Lisa, was this an adjourned review hearing, Dave?
It was adjourned from May 8th because you were off.
I see. Okay. I see.
The file was with the prosecutor.
Yeah, he didn't send anything in. This is Trent. Where's Trent at, do you know?
236.
Hello?
Mr. Bologna, can you come into the courtroom for a minute, please?
Absolutely, Your Honor.
Thank you. Lisa, it looks like both of these were taken under section 771.1. Is that true?
That's correct.
Come on in here, please. Your appearance?
Anthony Bologna, the city attorney, Your Honor.
It looks like she pled the 2 counts of A and B, and she's here for a review hearing. And they were both taken under section 771. It says she's still going to anger management. I sentenced her May 23 of 24. Ma'am, how far along are you in the anger management program?
Sir, I've completed my anger management. I think you guys are mixed up between my mom and myself.
Oh, my God.
Co-defendant.
My gosh, it's Rebecca Elter. My apologies. Well, it says she still has to complete. You're Rebecca?
No, I'm April author.
My mistake. April Marie Elter, 214-640-530. Your name?
April Marie author.
Compliant. Okay, everything completed. You want to send in a dismissal on this one?
Absolutely, Your Honor.
So I'll hand you that one and we'll go from there. Thank you. So just have a seat behind you. As soon as I get his motion, I'll get rid of it, okay? Rebecca Christine Elther, 254-T640-562. Listen to this one too, counsel. Come on up here, ma'am. Your name?
Rebecca.
You haven't completed the anger management program
All
yet.
that happened was I was on mute and I went to go click over and then I'll come back.
It's a 12-week program, I hope. 18
I
weeks.
know, I accidentally missed the first day and then I thought she let me do it the second day.
I don't know what
So it's
that
time
means.
to go every Tuesday, right? From 6 to 8. And then.
How many times have you seen her?
This will be my second time.
Well,
I got.
you're way too late. Hang on, slow down, slow down. Just slow down.
And.
Slow down. I don't want to, please. Is this Beth Wilds? I need Ms. Wilds in here. I mean, I only have so much time to complete these. I took this under a statute and had to have everything done within a year. I don't know why we're still fooling around with this. You should have the 18-week program done months ago.
I'm new to Zoom. I don't know how to do that. My daughter showed me how to do it and I guess I was on mute. So was she. She asked me to answer a question. I couldn't do it because it hung up on me. We live in Belleville and you have no signal. You have to go to room to room.
Did you talk to your probation officer about
Yes, I did.
this?
She's on our way, Judge.
That's the reason why I had to pay the second time to do it over.
You're not done with
An hour
it.
and a half.
You're not done with it yet.
I know.
And we've run out of time. I can't keep these cases open forever. 771 case, ma'am, please stop interrupting.
Sorry.
771.1 cases have to be done within 1 year of the date of the sentence. I sentenced you May 23 of last year. That means we only have about 8 days left. And you're telling me you haven't gone to anger management. Ms. Wild's your name.
Elizabeth Lost, Your Honor.
She hasn't done it at all?
She has, in the sense of she was removed from her initial program. So she did attend some of them, but they unsatisfactorily closed her out for her lack of attendance.
Okay.
So she re-registered to start the program May 7th
Of this year?
of this year.
Oh, it's not, I'm not gonna, this is a section 771 case. I can't dismiss this. I don't know what to tell you. Mr. Bologna, you can talk to her and do whatever you want to do here, but I'm not inclined to dismiss it if she hasn't done what I ordered her to do. That was 18-week anger management. Something troubled me in that case. I don't usually order that type of long program like that. So that's what I'm going to do. You can go talk to the prosecutor, ma'am, and then we'll take care of this as soon as we can. Thank you. Thank you. Riverside Townhomes, are they ready, Jennifer?
Judge, he has 2 more tenants to talk to and he'll be ready.
Deerfield Estates versus David Fry, 25-01684. Deerfield Estates versus David Fry. Mr. Fry, unmute, start your video and state your name, please.
All right.
You got to state your name again, sir.
David Fry.
All right. Just stay right there. Keep that steady. I'm getting a good connection. Mr. Burns, you're here on this case, true?
Yes, Your Honor. Good morning.
Your name?
Michael Burns, P87855 on behalf of plaintiff. And I just want to inform the court, I'm bouncing between courts right now, but right now you have my full attention. I just wanted to make the court aware, though.
Mr. Fry, did you listen to and understand the rights?
Yes, I did.
Do you wish to speak to a lawyer?
No, I do not.
Do you wish to, or have you applied for funding?
No, I have not.
Counsel, what's the amount owed?
We're showing a rent to retain of $1,378.97, costs in the total of $188.35 for a total of $1,567.32, Your Honor.
Do you, what do you want, a judgment now?
Yes, Your Honor.
Any reason to dispute those figures, Mr. Fry?
No.
When can you pay this?
By next week, by next Friday, within like the next 10 days.
I'll tell you what, I'm going to give him a judgment after hearing, and I'm going to give you until May 27th to pay. That's the day after Memorial Day. Can you do that?
Yes.
So I'm going to give him a judgment after hearing. The writ date will be May the 27th, so you either have to pay up or vacate by that date, okay?
Absolutely.
And as long as you pay, you can stay in the property, all right?
Thank you.
So he's going to submit a judgment. I wish you well. Do you have any questions?
I do not. Thank you.
Have a good day. Deerfield versus Joshua. I'm sorry, Michael Joshua and Jennifer Joshua. File number 25-01685. Are the Joshuas here? Either one of them?
No, Your Honor, not on Zoom.
Counsel, you paid for a second mailing, I presume.
Yes, Your Honor.
You did. You can go ahead and take a default.
Thank you, Your Honor. Would you like the numbers, Your Honor?
I would.
We have Mr. Joshua made a payment this morning, which leaves a balance of rent of $307.59. Court costs in the total of $226.81 for a total judgment amount of $534.40. We'd ask if this amount is not paid, a writ issue on May 27th, 2025. No money judgments entered at this time.
Defendants failed to appear. Default judgments entered. Writ date will be May the 27th. The amount to be paid to state is $531.40. Deerfield versus James Railroad, 25-01686. Come on up to the podium, sir.
Your Honor, I was unaware he was here, so he has not seen the rights video.
Yep. You have to go listen to the rights. I guess I can verbally advise you. You have the right, your name?
James Railroad.
You have the right to a lawyer.
Okay.
You have the right to proper venue. You have the right to a jury trial. You have the right to apply for funding with a variety of agencies, the Department of Health and Human Services, the local coordinated entry agency, CARA, or the Federal Health for Homeless Program, and they may be able to assist you with some or all the payments. You do not have to have a judgment against you in order to receive assistance. If you want to apply for assistance, you tell me.
Yes.
So I'm going to ask you, first of all, do you understand those rights?
Yes, I do.
Do you wish to speak to a lawyer?
No, sir.
Do you intend to apply for funding?
Yes.
Okay.
I can pay for April and May at the end of May.
Well, I know, but are you applying for funding?
Yes. I got money. I have income.
I know, but listen to what I'm asking you.
Yeah, I can try to apply for funding.
Slow down. I just want to know if you want to apply, if you're going to apply for funding with one of those agencies first.
Yes.
We're going to adjourn this 2 weeks. We're going to adjourn it to May the 29th. I'll give you a time here momentarily. Defendant to provide written notice of your application for funding to the court. You have to provide the application for funding documentation to the court within 5 days.
Okay.
I'm going to adjourn the case to May 29th at
1:30.
1:30. Okay, so you have to do that within 5 days. You have to submit that application for funding that you submit.
Okay.
You have to bring it up here, okay?
All right.
All right. Do you understand everything?
Yes, I do.
You have any questions?
No, sir.
All right, we'll see you here then. Good luck. Deerfield versus Jimmy Witt, 2501687. Jimmy Witt here.
Not on Zoom, Your Honor.
Counsel, your appearance.
Michael Burns, P87855 on behalf of plaintiff, Your Honor.
All right, Mr. Burns, you can go ahead and take a default.
Thank you, Your Honor.
Paid for a second mealing. Go ahead.
Rent to retain is $1,291.86. Costs in the total of $186.73 for a total of $1,478.59.
By the way, you're not asking for late fees in excess of $70 a month, correct?
Let me check. It depends on the client, Your Honor. I apologize. For this client, Your Honor, no. No, we are not.
Okay,
Double
just to
checking
make
right
a note, if you see my name on the pleadings, you can't ask for me for more than 70 on a residential, okay?
I understand, Your Honor.
But I'll give you that judgment amount, 147,859. The writ date will be May the 27th. Anything else on this?
Not on this matter, Your Honor. Thank you.
You don't have any more, do you?
He has Water's Edge in South Glen, Your Honor.
Oh, okay. I'll go on to those.
Just love the court that much, Your Honor.
What's that?
I said I love the court that much, Your Honor.
Water's Edge versus Darren Armstrong and Madison Stewart, 2501706. Can I have your names, please? I can't hear a word you're saying. It doesn't appear as though you're muted. Now you're muted. No, you're not. No, you're not. Turn the volume up on your device.
Make sure you've allowed your device to use your microphone as well.
Yeah. Can you tell me, try to speak your name again?
Armstrong.
Nice and loud, nice and loud.
Darren Armstrong.
Ma'am, your name?
Madison Stewart.
Did you, the two of you listen to and understand the rights, Mr. Armstrong?
Yes.
Yes.
Ma'am?
Yes.
Do either one of you, let's start with you, Mr. Armstrong, do you wish to speak to a lawyer?
I would like to speak to a lawyer, yes.
Do we have any lawyers here anymore, Jennifer, ever, or how are we doing that?
Well, with this being a Thursday, they were not available, but I do have the contact information for Lakeshore that they can reach out to.
I'll adjourn this a week and you can reach out to the lawyers. When are we going to put it, Jen?
I can, if they want to chat me an email address, I can email it to them.
No, I know, but when are we gonna do this next week?
The 19th at 10:30.
What day?
The 19th, we have next Monday. Do you want to go to the 29th to give them time?
No, we're gonna go to the 19th at 10:30. They're gonna send you the chat information and you can call the office and speak to the lawyers right now, okay? And tell them your court date is on Monday. So that's, how much is owed on this, Mr. Burns? Tell me your name again if you haven't already.
Of course, Your Honor. Michael Burns, P87855 on behalf of plaintiff. There's rent to retain of $1,000.
I just need the total balance.
Yes, Your Honor. $1,078.15.
You gonna be able to pay that?
Oh, that's just it. We applied for assistance and we also, it's not rent. It's a water bill that we did not have access to.
All right, let's slow down. Let's just slow down. So you're likewise applying for assistance?
No. Yes, sir. Yes, Your Honor.
Have you?
Yes, we have. Just last couple days. We didn't actually get our summons handed to us. It was left on our porch.
All right, slow down. Well, you don't, okay. Here's what I'm gonna do. You have to provide proof that you've submitted an application for funding. You have to submit it here to the court, not the application. You have to provide proof that you've submitted the application to a funding unit within 5 days.
Okay, I understand.
So you have to bring it up to the court. I can give you that until May the 29th. That's when we'll have your next hearing date, and that'll be on at what time, John?
1:30.
At 1:30. So May 29th at 1:30 now. Okay, so but you have to submit that application, proof that you submitted an application for funding within 5 days here, okay?
Yes, Your Honor.
All right, ma'am, any questions?
No, Your Honor.
Sir, any questions?
No, Your Honor.
All right, good luck. Thank you. South Glen versus Eliza Brown and Kyla Brintley, 2501708. Are either one of them here, Jen? Eliza Brown or Kyla Brintley? Jennifer, can you hear me?
Yes, Your Honor.
Are either one of those defendants here, Eliza Brown or Kyla Brintley?
No, Your Honor, they have not checked in.
Counsel, you can take a default.
Thank you, Your Honor. The total due of rent currently is $460, costing the total of $200.
I ask you to break down the rent, the late fees too.
Yes, Your Honor, and I actually just did the math. The late fee that was assessed was $100, so I subtracted $30 from what our client is claiming. So the last time there was a zero balance. Since then, there has been a pet fee of $35. There's been rent of $1,160. There's been a water bill of $30. There's been insurance of $37. There's been a gas bill of $30. There is a washer and dryer fee of $35. There is a credit associated to the account of $37. And then there was the late fee of $100. The client then, or I'm sorry, the tenant then made a payment of $900, which brought the balance to $490. So subtracting $30 from the late fee would bring the total due of rent to $460.
All right, and so what now other costs do you have?
We have costs in the total of $222.55, which brings the total past due and owing to $682.55.
Default judgment will enter in that amount. Writ date will be May the 27th. The amount again to be paid to save it from the issuance of the writ is $682.55. and 55 cents. You can submit your judgment. Thank you.
Thank you, Your Honor. Appreciate the court's time today.
Alex Christopher Pittock, 25B1479388A. Your name?
Alex Christopher.
You're charged with failure to enroll in biweekly chemical testing as ordered on April 29th of 25. That is the charge. If you plead guilty or if you're found guilty, you could be incarcerated for up to 5 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
You have the right to a lawyer. I'll be happy to give you one at public expense if you want one. Do you want one?
No, thank you.
Where's the arraignment? All right. So I'm going to ask you now, with the charge you failed to enroll in biweekly testing as ordered on April 29 of 25, how do you plead?
Not guilty, sir. It was a miscommunication, I believe. I was never informed that I needed to enroll.
Hang on a second. I'll get the probation officer in here and we'll have a hearing, okay? So you can have a seat. We're going to get Emily Tessino in here on this one.
Okay.
We'll see. Thank you. Al-Shami. Amin Hamoud Ahmed Al-Shami, 25R 514-112.
Good morning.
Your name?
Amin Hamoud Al-Shami.
You're going to plead guilty under section 771.1 to furnishing alcohol to a minor, true?
It's cigarettes.
Yeah. I'm sorry, tobacco. My mistake. You understand that?
Yes.
Is that what you want to do? You understand I'm going to place you on probation and I'm going to set terms, and if you're compliant at the end of 6 months, the case will be dismissed.
Please, thanks.
Did you sign the advice of rights and did you understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, sir.
All right. You still have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? To the charge furnishing tobacco. To the charge furnishing tobacco to a minor, how do you plead? On April, how do you plead?
I'm sorry?
To the charge furnishing tobacco to a minor, how do you plead?
You want me to explain it?
No, I want to know if you plead guilty or not.
Oh, yeah, guilty.
On that date, April 19 of 25, were you working at 22430 Huron River Drive in Rock?
Correct.
What kind of station is that?
It's a tobacco and vape.
All right.
Yes, sir.
And did you sell tobacco to somebody that was less than 21?
Yeah.
Why?
Because to be honest, I've been in the business for 17 years and I never had taken before. And he looked a little bit older to me. And I was at the end of the day, I was about to close. I wasn't paying attention,
I'm listening.
Yeah.
Why did?
I have kids. I never.
Why didn't you check his ID though?
I always check it, but it's happening mistakes sometimes, 17 years, I never had to take it.
Okay, I get it, but why didn't you check his ID?
I always check, but I don't know, just happened.
You own the store?
It will never happen.
Slow down. Do you own the store?
I do, yes, sir.
And you've never had one of these?
Never.
Call in, Mr. This is Pellet. 1 second. Yeah, where is my sheet? Hang on. Do you have the number?
I always have certificate, thank you for not selling tobacco, actually.
I know, but why did you not get the idea of somebody who's 19? I don't want to make this
You
big.
look a little, I don't know. It happened. Sorry.
Hey, George, hey, Jen.
Well, then you're not checking IDs all the time, though.
Okay, thanks. He's coming in.
How you doing, Mr. Bond?
Good, Your Honor.
Your name?
James Cullen on behalf of the city of Rockwood.
Did you guys ever amend your ordinance? The ordinance section I have is talking about under 18.
I think it's actually state law that,
Well, but they wrote it under local ordinance. If you guys didn't adopt
I believe we've adopted.
well, you better check. Because you guys he cited ordinance section 231-1. And it talks about furnishing tobacco to somebody under 18. And this kid was 21. So I don't know.
No, he was under 21, but
No, I know, he was 19.
yeah.
But the ordinance you have here, at least the one.
I mean, I would assume we adopted it.
All right, well.
I don't have it off the top of my head.
I got it. Mr. El Shami, look, he's got to do some checking into this. I don't know if they adopted the ordinance or not. I don't want to keep you waiting here. I'm not going to take the plea. I'm going to reschedule it, and he'll have the ordinance section for us next time. Or if they didn't adopt it, then they're either going to have to charge you under state law, have you charged under state law, or I'm going to dismiss it. Okay? I'll just make a note. The ordinance. Cited.
Judge, just so you know, there's several of these on the docket today.
Well, that isn't good. Do you want to try to check it now? I don't think you got one. I mean, you guys usually provide us with ordinances. Look, here's what I'm going to do. If not amended, I'm just going to adjourn this.
I thought it was written under state law. I didn't look at it.
Well, yeah, but if it was written under state law, you got no business handling it, no disrespect intended. And he cited a local ordinance, and he checked the local ordinance.
Doesn't it incorporate the state law is what I meant?
I don't see where it did. I didn't look.
Let me look at it. What, you may want.
231-1.
All right.
I'm adjourning this for you. I don't want you to, I don't want to take any, I don't want to make you come back, but I'm going to adjourn this, okay? Lisa, what do we have? Is Mr. Pellin here the 29th?
29th at 8:30.
Okay?
29?
Yeah, and let him look into it. I hope I'm not making you come back just for nothing, but I want to make sure, all right?
Okay, what do we need to do? 29 and 8:30, I have to come here?
Yes, sir.
Okay.
Okay, go down the hall, get your notice, and we'll see you back here then, okay?
Thank you.
Thank you. You want my book?
Now I'm gonna look it up online because that'll show it.
Good enough. That might be the problem. Alex Christopher Pittock, 25B147-938A. Your name?
Alex Christopher Pittock.
Your name?
Emily Tito.
I'm entering a not guilty plea for him. You still wish to waive your right to a lawyer, sir?
Yeah.
So he's saying there was some kind of confusion as to when he had to sign up for testing or didn't know. That's what he started to say. So I'm calling you in and I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
All right, go ahead.
only thing I can go off of is I do have the referral that I filled out and would have went over with Mr. Patak when I did his instructional.
When was that?
His instructional would have been the day of his sentencing, which was April 23rd, but on my referral, it clearly states testing start date is April 29th of 25. So that
Okay.
there could have been confusion. He did go test on May 5th. That was his first test.
Do you have any questions of her?
I started calling.
I want to know if you have any questions for her first.
No.
You want to testify? If you do, I swear to you to an oath, as
Yeah,
I just did her.
yeah, that's fine.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, sir.
Okay, go ahead.
I began calling the number for the testing on the 29th because I was under the impression that I was already enrolled. So the start date, like she said, the 29th, I have the call logs that I called every single day since the 29th. And the first time I was called up there, I went, so I didn't miss any testing or anything. And I've been doing everything else for my probation, going to AA, therapy, all that, the court work program. So there was no ill intent by me not enrolling. It was just a misunderstanding.
I'm not sure why it was a misunderstanding. The sheet clearly spelled out you had to enroll by the 29th.
The way that she told me I had my color and everything, and that I started testing on the 29th, I was unaware that I needed to go up there and enroll.
All right, look, I'm gonna make this easy. I think it was your fault. I'm gonna find you guilty. I'll chalk it up to a warning. No costs, no sanctions. We'll let it go with that. But make sure you cross your T's here and dot your I's, will you please? Thank you very much. Have a great day.
Judge, Mr. Mudar is back. I just wanted to let you know.
All right, I'm gonna take Jaleesa Maria Rodriguez. Are you ready on that?
Yes.
25R514085A. Tell him if he wants to check back in about 15, well, go ahead, counsel.
Good morning, Ms. Rodriguez.
Ma'am,
Jaleesa Rodriguez.
your client was in here and tendered a plea of guilty to the charge of operating while visibly impaired on May the 15th. She was referred for a screening and assessment. Have you had, she did score in category 1, I'm gonna give her that. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
We haven't had a chance to review the report, Judge. It is factually accurate. We've got no corrections, omissions. We do ask the court for a couple of amendments, Judge. We've read the recommendation, and Judge, just like you mentioned, she did score 1 in both categories on the needs assessment. So I believe that the recommendation may be a little harsh for the outcome here. This is a first offense for Ms. Rodriguez, alcohol related or otherwise criminal in general. She's a single mother, Judge. She is full-time employed. She's been with the same employer for the last 5 years. She does have 3 minor children that live with her. Judge, this was a one-off offense. We'd ask the court to not sentence her to probation, but rather costs and fines, Judge.
She's got all kinds of warrants out.
She's taking care of those, Judge. She has the proofs here with her.
She scored twice the legal limit, more than twice the legal limit on an OWI.
I did explain that to her as well.
That troubles me.
And she does assure me that because of one-off, this has never happened before. She assures me this will never happen again. She does understand that what she did was she made a mistake, and her record does reflect the fact that she's never had any issues prior with alcohol.
All right, let me check something here. Boy, I got a mess going on over here. All right. I'm going to place you on. Ma'am, have I let you finish? Is there something you would like to tell me?
Yes, I just wanted to apologize. I kick myself every day I know I could have been hurt or I could have hurt somebody else. It's not only taken from me, but my kids, they're all in honor school. They've been missing out on their after school activities because I cannot drive to take them. It's hard to find a ride. I know what I did that was wrong. I wasn't feeling good where I was at and I left. And it was a mistake.
All right, good enough. I'll reduce the probation period. I am troubled that she's got almost 2.5 times the legal limit, or certainly more than 2 times. But I'm going to go light on you. 9 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any. I'm just going to make chemical testing, PBTs, and ETGs on demand of the probation department. So if they tell you to go, you have to go. Kratom, poppy seeds, CBD oils, any of those are prohibited. If you consume food or other items containing those substances, that will be deemed a violation. I'm going to have you do the alcohol education program level 1 in the victims impact panel. I'm going to order 2 days jail credit, 1 serve 1, and I'll have you do that by way of community service. 8 hours of community service you have to complete by June the 30th. Again, you're to attend the alcohol education level 1 program with the victims impact panel. Fines are $300, cost $250, $75 victims' rights fee, $50 justice assessment fee. So fines and costs are $675. There's a screening fee of $60 for $735. You have probation fees of $180, bringing your total to $915, plus you have cost of recovery of $150 for $1,065 and court-appointed attorney fees of $40. I want to double check my math here. That's right, 1105. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You may be eligible for early discharge. You do everything, stay out of trouble, no violations within 90 days, you can get off of probation in 4.5 months, okay? So get going on this. I'm going light, scored in category 1 on both drug and alcohol, and I'm doing more than reasonable, but that's the best I'm gonna do. Do you understand it?
Yes.
Do you have any questions?
No.
She'll require a payment plan. She can take care of that.
How much can you have today? Do you have today?
No, I just took care of this, the warrant, $600.
Just fine. You don't need to explain. Tell me how much you can afford to pay weekly or bi-weekly. You make $1,500 bi-weekly, right? So you do pretty well.
Yeah, with bills and stuff.
I know, we all have bills. How much do you actually make? What's your gross salary?
I make $19 an hour.
Okay. Tell me how much you can pay weekly.
I'm not sure.
Well, come on.
$50.
Weekly? Okay, if that's all you can do, that's fine. I'll let you do that. You pay $50 weekly, and I'll start this beginning on May the 27th. And if you don't have the money on any one of your due dates, all you have to do is come talk to me on or before the due date at 8:30, or call the court, say I need to go online with the judge. I'll give you an extension. I honestly don't care how many times we have to do that. So just don't ignore me. Don't be afraid if you don't have the money, okay? Thank you very much. Zarate. And you're gonna meet with probation before you leave there. You're gonna meet with probation before you leave, ma'am.
Yeah, she's going across.
Joshua Michael Zarate, 25F243398.
Good morning, Judge. I'm asking you to appear to have Mr. Zarate.
Where is Mr. Zarate?
Mr. Zarate, I thought was in here.
Did you talk to him?
I did talk to him, Judge. I thought he was already good.
Why come into court when you're going to court? You might stay out in the hallway. I don't understand it. I'm gonna go on to another case.
I've got 2 more in front of you, Judge. You want to?
Which ones? Davis, Jeremiah Davis?
Davis and Gordon.
Jeremiah Mitchell Davis, 25F243817, and Raymond Gordon, have a seat at the table there.
Mr. Davis, come on. Mr. Gordon, have a seat right there.
Your name, sir?
Jeremiah Davis. Good morning, Judge. I'm asking you to appear to have Mr. Davis.
All right, this will be a plea under highway, right?
Yeah, for arraignment purposes, Judge, we'll stand it way.
All right, so if you plead guilty here, sir, I'll take this under an act, under a statute, and I'll set terms and conditions, and if you're compliant at the end of that specified period of time that I set, the case will be dismissed. This is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign the advice of rights?
The yellow sheet, yes, sir.
Did you read it and understand it?
Okay.
If you plead guilty, you'll be giving up all those rights, and there will be no trial. Do you understand that?
Yes, sir.
You understand everything? Any questions?
Sorry.
To the charge of child neglect, how do you plead? On May 2nd at 25 at 6:50 PM, were you, is that a Myers at 26100 Freeland in Flat Rock?
Yes, sir.
Did you leave your 5-year-old child in a vehicle?
I did.
Why? Why would you do that?
He was sleeping and it was irresponsible of me. I just went to run to the store to get him some groceries and stuff, and that's what I was doing. And I came back out to the car and there was a cop around there. It was honestly terrifying to see that.
Are you on probation or parole?
No, this is my first criminal offense.
Anybody force you to plead guilty?
No.
Well, I gotta set a sentence date. I feel like I want to order them printed on this. I mean, I'm not gonna, there's no reason for you to be real nervous, but you just can't do that. You have to go over to Flat Rock Police Department to get photographed and fingerprinted today by 1 PM, okay? I'm not ordering a pre-sentence report. I'll take the plea, I'll sentence him, I'll look over the report, and I'll get a sentence date here. So here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. You have to get fingerprinted and photographed, as I said, by 1 PM today. And that is about it. So you gotta use your head though, okay?
Yes, sir. Personal bond.
Yeah, I'm giving him a personal bond of $500 if I didn't say I wrote it down, but, and you're all set. So we're gonna give you a sentence date right now, then you'll go down the hall and get that date, and you'll get also your paperwork to go over to Flat Rock to get fingerprinted and photographed, okay? All right, Lisa, what do you have for me?
May 29th at 8:30.
May 29th at 8:30, sir? May 29th at 8:30.
May 29th at 8:30?
Correct. So you can go down the hall, get your notice, get your order for prints, and go over to Flat Rock, okay? Best of luck to you. Thank you.
Thank you.
Raymond Charles Gordon, 25F243-947A and B.
Good morning, Judge. Matthew Whitaker, Baptist Gordon. Mr. Gordon's taking the record. Brandon Gordon.
You stand to me at wage formal reading?
Yes.
We're just gonna arraign today?
We're just gonna arraign, yes.
Not guilty, pleas entered, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Your pretrial date in this case will be on
May 29th at 8:45.
May 29th at 8:45. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay, sir?
Yes, sir.
All right, so if you want one, he'll give you one. You fill it out, hand it back, go down the hall and get your notice. Any questions?
That's secret there.
Any questions?
No, sir.
Okay, good luck.
Judge, Mr. Zarati's here. Do you want to do that sentence?
Where'd he go?
He's right there in the blue shirt. I think maybe the one right in front of him.
Joshua Michael Zarati, 25F243-398.
Good morning, Judge. Matthew Whitaker here, back to Mr. Zarati. Mr. Zarati's taking the record. Joshua Zarati.
All right, so he's going to be sentenced today. He pled guilty previously. The plea was taken and impaired. The OWI was dismissed. He was referred for screening and assessment. Have you had the chance to review the report with him, and are there any material additions, corrections, or deletions?
We have had a chance to review the report, Judge. We have no corrections, additions, or deletions at this time.
Okay, is there anything you would like to say on his behalf?
Yes, Judge. I mean, this Mr. Zarati, this is a first offense for Mr. Zarati. Judge, he's a responsible individual. He does actually, he's been long-term employed at Haddix Electric. He's actually an electrician. He doesn't have a previous criminal record. He doesn't have any other alcohol-related offenses. Judge, this was a mistake, obviously, and he knows he made a mistake. I've discussed with him the consequences of that mistake, and he understands.
Let me see his AA attendance, okay?
Sure, do you have that with you? Yep.
Boy, you really had a high blood drop. You know that, right?
I do.
3.5 times illegal limit.
I do, Your Honor.
You're 25. I don't want to be the bearer of bad news, but I'm just going to be honest with you. When I see results like this of people in their young 20s, the likelihood of them coming back is extremely high.
Yeah, Mr. Zarate is letting you know that he's currently also, he is attending the AA classes. He's found them very beneficial, and he feels like that even if the court did not order it, he does plan on continuing to attend the AA classes.
Yeah, this concerns me. Is there anything you'd like to say, Mr. Zarate?
I'm very sorry for my actions. I understand I made a terrible mistake. Getting in trouble is not my ideal situation. It's not something I'm used to. I do recognize it was a terrible, terrible mistake. And again, I just deeply apologize. I'm doing everything I can to correct the issue, and I will 100% abide by any probation, any court proceeding that needs to be done for this scenario in order to make this right.
I can't go along with this recommendation. I mean, I'm telling you truthfully, if you don't recognize right now, I don't know if there was underreporting, there had to be. If you don't recognize you have a problem, you're going to be back in front of me or other judges real soon.
I do understand that.
15 months probation. You cannot leave the state without consent of the court or violate any law. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to obtain and maintain employment. You're to submit the chemical testing, PBTs, and ETGs. I'll make it bi-weekly for 4 months. If you're clean, then I'll make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I do want you to be on a Sovalink device, a breathalyzer machine you're going to have to blow into by the end of the day, and you have to have that on for 60 days. 5 days jail credit, 1 serve 4. I'll let you serve those as follows: 3 days on our court work program, 8 hours of community service in lieu of jail. So you don't have to serve any jail, but you're going to do 3 days court work, 1 day community service. Community service has to be completed by June the 30th, and they're going to schedule you on our court work program. You're to obtain and maintain employment, provide proof. You're to continue to attend AA, NA 3 times a week until you're in an outpatient treatment program. Once you get in an outpatient, you no longer have to attend AA or NA. You do have to, so in other words, if you get in outpatient this week, you don't have to go to AA or NA anymore. And I'm going to hand you back your sheet here, Mr. Gay. 3 times a week until an outpatient. Again, once an outpatient, you no longer have to attend. You also have to go to the Victims Impact Panel. 300 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, $60 screening fee. All of that comes out to $785. You have $225 in costs of recovery, bringing your total to $1,010, $40 in attorney fees, that's $1,050, plus your court work program fees of $105, that is $1,255. If you violate, your probation could be revoked, you could be incarcerated for 93 days, you have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
All right, do you have all of this to pay?
We'll be requesting him.
How much does he have today?
Do you have plenty of papers?
I get dropped $400 today.
Okay, you pay $400 by 3 p.m. Okay, you can do that?
Yes, Your Honor.
Judge,
Yeah,
did you add the work program?
I thought I did.
Okay, I just got a different total, sorry.
Well, wait a minute, let me double check. 780, 7 and a quarter, 785, 825, 1,025, 1,050. Wait a minute. All right, let me start over. 7 and a quarter, 785. 985, 1,010, 1,050. You're right. What are you coming up with? 1155?
I got 1455, but maybe I have the fines and costs wrong.
Okay, let's do it again. 300 fines, 300 costs, $75 victim's rights fee, $50 justice assessment. That's 7 and a quarter. The screening fee is 60 for 785. Attorney fees are 40 for 825. Cost of recovery is 225, which should bring it to 1,050 plus court work program fees of 105. Yeah, it should be 1155, I think.
The probation fees?
Oh, thank you. Thank you. Thank you. Thank you. See, I got this competent staff. They always correct me. 1455 is your total. That includes $300 in probation fees. Okay. You're saying you can pay 400 by 3 p.m. and then balance at the rate of, actually, that's a little high for me. I'm gonna reduce the cost to 200 and make it 1355. Okay.
Thank you, Your Honor.
And then you pay 400 by 3 p.m. And then how much can you pay weekly?
I can do,
I don't want you to set something you can't make. So can you make $650 a week? Can you pay $75 per week?
yes, Your Honor.
Are you sure?
Yes, Your Honor.
75 per week beginning. May the 3rd. If you ever need more time, don't get panicked. I'll give you more time. Just call the court. We'll go on Zoom, or you can come up here on or before the due date at 8:30. I'll be more than happy to work with you, okay?
Thank you, Your
All
Honor.
right, good luck to you. And you'll meet with probation, and you have to get your SoberLink device by the end of the day, okay? I'm gonna real quick take Alfred. Are you ready on those? Ms. Alfred, what's your first name again? April Alfred, come on up here. Did you write up a stick for me, counsel? You did. People against April Alfred, 214-640-530. Your name?
April Marie Alfier.
Raise your right hand. Solemnly swear affirm that the penalties of perjury, the testimony you'll give in these proceedings will be the whole truth, so help you God.
I swear.
Since you were in court when I sentenced you originally, have you been arrested for any reason?
No, sir.
Any contact with the police?
No, sir.
I'm gonna go ahead and dismiss. Motion to prosecute. Case dismissed. Thank you very much. Good luck.
Thank you as well.
I gotta go on to these others. I got these landlord tenant people waiting for me all over the place here. Jeez. Riverside Townhomes versus, Riverside Townhomes versus,
Judge, there were 2 cases for Althor.
yeah, I know, there's another one, but I'm gonna have to deal with that in a second. That's her mother, Rebecca Alford, right? Yeah, okay. Riverside Townhomes. Let's do that. Riverside Townhomes versus, all right. Thomas Paquette and Allison Paquette, 2501674. Counsel, your appearance?
Max, Jeff Mood on behalf of plaintiff, Your Honor.
Sorry to keep everybody. It's been busy here. Paquette's your name?
Thomas Paquette.
And ma'am, your name?
She's in the restroom right now.
Riverside Townhomes versus Tricia Wansowitz and Carson Wansowitz, 2501676. Ms. Wansowitz, your name?
Trisha One Savage.
All right, sorry about that. Mr. Mudar?
Max, Jeff Mudar on behalf of plaintiff, Your Honor, we do have a resolution on this matter.
Go ahead.
So we've got a consent judgment as to Tricia and a default as to Carson, with the same terms applying to both tenants. We've got.
Karen, I want to make sure you're not charging more than $70, right? Per month in late fees? I don't give that, so if you've got it in there, you're gonna have to change it.
No, Your Honor, it looks like the client is charging $50 late fees.
Good enough. Go ahead. What are the terms?
So we've got rent to retain being that $3,707, court costs in the amount of $179, giving us our grand total $3,886. We're providing until May 27th to either pay that balance or vacate the property. We've got language in paragraph 10 that indicates if defendant pays or vacates timely, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from defendant Tricia to add her signature to this resolution, and we did go over MCR 4.201J.
All right, ma'am, do you understand everything he said?
Yes.
He says that you owe $3,886. Do you agree that you owe that amount?
Yes.
Understand if you pay that amount on or before May the 27th, you can stay in the property, the judgment will be deemed satisfied, and in fact, he's going to move to dismiss the case.
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
All right, so this will be entered as a default versus Carson and a consent versus you. Do you have any questions?
No, I just do want to state that with Carson, it's kind of my fault. She didn't realize she had to be here, and I didn't tell her. She's 19, so she's never gone through any of this. So that's totally my fault, and I apologize.
I move to dismiss that if they pay too, counsel, right?
Yes, of course, Your Honor.
Okay, you're all set. I wish you well. Good luck. Thank you.
Thank you.
Thank you.
Paquette, are the Paquettes, she out of the bathroom yet, sir, or not?
Yes.
There we
Yes,
go.
I'm here.
Riverside versus Thomas Paquette and Allison Paquette, 250-1674. Your names again?
Thomas Paquette.
Allison Paquette.
Counsel,
Max, Jeff Mudar on behalf of plaintiff, Your Honor, we do have a resolution on this one.
go ahead.
So we've got a consent judgment, rent to retain on it being $2,767.
I'm sorry, I didn't hear that. You cut out.
I do apologize, Your Honor. So we got a consent judgment, the rent to retain on this one being $2,767. Court
Okay.
cost fund of $179, giving us our grand total here today of $2,946. We're providing until May 31st of 2025 to either pay that balance or vacate the property. We've got language in paragraph 10 indicating if paid timely, parties agree to stipulate to set aside the judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from both Allison and Thomas to add their signatures to this resolution, and we did go over MCR 4.201J.
All right. Mr. Paquette, is that true?
Yes.
Mrs. Paquette, is that true?
Yes.
So you both agree and understand the following, that you owe 2946, you have to pay by May the 31st. If you do, the judgment will be deemed satisfied, you stay in the property, and then he will move to dismiss the case. If you fail to pay up on or before that date, the judgment will remain in effect. He'll submit an application for a writ, and if you haven't moved out, you're going to be evicted. You understand that, Mr. Paquette?
Yes.
Ms. Paquette?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. Do you understand that, sir?
Yes.
Ma'am?
Yes.
And he has your permission to sign your name, Mr. Paquette?
Yes.
Ms. Paquette?
Yes.
All right, I wish you guys well. He'll submit the judgment. I sincerely wish you good luck. Thank you very much. Riverside Townhomes versus Brendan and Cheyenne Adams, 250-1678. Mr. Adams, your name?
My name's Brendan Adams, sir.
Cheyenne? Is she here?
No, sir.
All right. Counsel, did you talk to Mr. Adams?
I did, Your Honor. Maxfield Mudar on behalf of plaintiff. We do have a consent judgment on this one. Consent as to Brendan, default as to Cheyenne. We've got a rent to retain on this one in the amount of $1,240.51. Court costs in the amount of $179, giving us our grand total here today of $1,419.51. We're providing until June 4th of 2025 to either pay that balance or vacate the property. We've got language in paragraph 10 indicating if paid timely, Parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment.
I'm sorry, I apologize.
Not a problem, Your Honor. I have received permission from defendant Brendan Adams to add his signature to this resolution, and we did go over MCR 4.201J.
Is that true, Mr. Adams? You have given your permission to him to sign your name to that proposed consent judgment?
Yes, sir.
Do you agree that you owe 14/1951?
Yes, sir.
You understand a judgment will enter in favor of the plaintiff and against you in that amount with a writ date of June the 4th. If you pay by June the 4th, you can stay. If you don't, you're going to be evicted if you haven't vacated. And also, if you do pay by June 4th, they're going to motion to dismiss the case. This will be by default versus Cheyenne and by consent versus you. Do you understand that?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you also have 10 days to appeal. Do you understand that?
Yes, sir.
Any questions?
No, sir.
Okay, you're all set. I wish you well. Good luck. Thank you very much. Riverside versus Amaya Fisher. Is she here? 2501671. Ms. Fisher, good morning. Your name?
Good morning, Amia Fisher.
Counsel?
Actually, Buddha, on behalf of plaintiff, Your Honor, we've got a consent judgment on this one. Rent to retain possession being $1,658.50. Court cost the amount of $179, giving us our grand total here today of $1,837.50. We've got a writ date on this one of May 27th, 2025. Then we've got language in paragraph 10. If paid time, parties agree to stipulate, set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from the defendant to add her signature to this resolution, and we did go over MCR 4.201J.
Do you agree to all that, Ms. Fisher?
Yes.
Do you understand and agree that you owe $1,837.50 and that this will enter in this will be set down in a consent judgment whereby you must pay up or vacate by May the 27th. If you do that, you can stay in the property and the case will be dismissed. If you fail to do that, you have to vacate. If you don't, you're going to be evicted and the judgment then would remain in full force and effect. You understand that?
Yes.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
All right. Do you have any questions?
No.
All right. I wish you well, and he has your permission to sign your name to this, correct?
Yes.
Thank you very much. I wish you well, ma'am. Good luck. Counsel, do you have any more Riverside ones?
Judge, there was the one that Linda brought you down, Hancock.
Riverside versus Seamus Hancock, 2501673. Is Seamus Hancock here?
No, Your Honor, defendant did not appear.
All right, you got a second mailing. Go ahead and take your default, counsel.
Thank you, Your Honor. At this time, plaintiff moves for the entry of a default judgment. Rent to retain on it being $2,892.33. Court cost in the amount of $179, giving us our grand total here today of $3,071.33 with a writ date of May 27th, 2025.
Defendant failed to appear. The relief request will be granted. There is a default judgment of possession in favor of plaintiff against defendant. The writ date will be on the 27th of May. 307-133 is the amount to be paid to save it from the issuance of the writ. All right. Let's take, you have more. You have Waterway or whatever, right?
South Point Square.
South Point. I'm going to go take this one case. Rebecca Christine Alther, 242-640-562. Come on up here, ma'am. Your name?
Rebecca Christine Alther.
Anthony Bologna, Beth State Treasurer.
So, what do you want to do?
I had a talk with the defendant. She claimed she had technical issues for whatever reason. Took her a year. She's still going to comply. As court knows, 771, it's a year max on probation. So I'll leave it to the court's discretion.
Conviction is entered. We're going to set this for sentencing. I really wish you would have done this. We'll set this for sentencing. I want to look at this file again. Lisa, give me another date.
June 9th at 1 o'clock.
I'm sorry, what day?
June 9th at 1 o'clock.
June 9th at 1 o'clock, ma'am. I don't know why you didn't do that. I'll see you here
So
June.
I keep doing my resignation, no.
You don't have to now. I mean, I'm revoking your status. I'm gonna sentence you anew. I'm probably gonna order anger management, so I don't want you to come in here and say, gee, Judge, you told me to stop doing it, now I gotta pay again. So you,
No, I was trying to finish.
ma'am, just let me finish. So you might want to keep going, okay? That's what I would do. And then you can remind me and bring me proof that you've done it, but you have to do it, okay? All right, so go down the hall, get your notice, and I'll appoint you a lawyer. Give her a petition for a court-appointed lawyer down there, will you, Lisa, please? Thank you very much. South Point versus David Carter, 2501664. Appearances, gentlemen.
Maxfield Mood on behalf of plaintiff, Your Honor.
Mr. Carter, good morning. Your name? You have to unmute. Mr. Carter, your name? He's frozen. All right. South Point versus Diana Ostowski. I already did that one, I believe, right? Yes.
Yes, Your Honor.
Okay, so I've got South Point versus Tiara Matthews and Eli Moton Jr.
That one we completed, Your Honor.
667.
We completed that one.
Thank you. Okay.
We got Johnson.
Kyla Marino and Robert Mendoza, 2501668.
Maxfield Mood on behalf of plaintiff, Your Honor.
Where's Robert Mendoza?
I'm here, Your.
You have to tell me your name, sir. I don't see you.
Robert Mendoza.
Do you see him, Lisa? Oh, there you are. I'm sorry. I apologize. All right, counsel, why don't you go ahead and proceed with your terms here if you have a consent.
Thank you, Your Honor. We do have a resolution on this one. So we've got the consent as to Robert Mendoza, default as to Kayla Moreno, but of course, same terms apply. So we've got a rent to retain on this one in the amount of $1,750.84. Court costs in the amount of $179, giving us our grand total here today, $1,929.84. We're providing until May 31st of 2025 to either pay that balance or vacate the property. We've got additional language in paragraph 10 indicating if paid timely, parties agree to stipulate, set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from Mr. Mendoza to add his signature to this resolution, and we did go over MCR 4.201J.
Do you agree that you owe that amount, 1929? Is it 89? I can't even read my own writing.
We got 84 cents on this one, Your Honor.
84 cents. 1929.84. Do you agree that you owe that amount, Mr. Mendoza?
Yes.
And does he have your permission to sign your name to a proposed consent judgment that calls for you to pay that on or before, what date did you tell me here?
We had May 31st on this one, Your Honor.
On May the 31st. If you do that, you can stay in the property, the judgment will be deemed satisfied, and he'll move to dismiss. If you fail to do that, then I want you to understand that the judgment will remain, you'll be evicted, and you'll have to, if you haven't moved out, you'll be evicted if you haven't paid by then. Do you understand that?
Yes, sir.
You have 3 business days to come in here and fill out a motion to set aside the judgment since you're unrepresented, and you have 10 days to appeal this. Do you understand that?
Yes, sir.
Any questions?
No, sir.
I wish you well. Thank you. Good luck.
Thank you, sir.
Thank you.
We have Romantic Smith. We ready on that?
But yes.
South Point versus Romantic Smith, 2501670. Your name, sir?
Alan,
In all occupants. You're Alan Smith. State your name, please. Mr. Smith, you have to speak up, please.
Alan Smith.
Okay, counsel, go ahead.
Thank you, Your Honor.
With the
So we've got a consent judgment on this one. Oh, Maxfield Mood on behalf of plaintiff. I do apologize, Your Honor, on the day. So we've got a consent judgment on this one as to Alan Smith / all occupants, a default as to Romantic Smith. We've got a rent to retain on this one in the amount of $2,563.83. Full cost in the amount of $179, giving us our grand total here today of $2,742.83. We're providing until May 31st of 2025 to either pay that balance or vacate the property. We got language in paragraph 10. That is my standard of, if paid timely, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from tenant Alan Smith to add his signature to this resolution. We did go over MCR 4.201J.
Sir, do you understand everything he said?
Yes, Your Honor.
You agree to show 274283, and then there will be a consent judgment entered versus you today, a default versus the occupants, including yourself, and a default versus Romantic Smith, with the understanding this has to be paid by May the 31st. If you do that, you can stay. If you don't, you will be evicted. If you do pay by that day, the case will ultimately be dismissed, and you can stay in the property. Do you understand that?
Yes, Your Honor. Thank you.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, Your Honor. Thank you.
And does he have your permission to sign your name to that proposed consent judgment?
Yes, he does, Your Honor.
All right. I wish you well, sir. You're all set. Anything else on that one, Mr. Mudar?
Nothing further from plaintiff, Your Honor.
Thank you. David Carter, South Point versus David Carter, 2501664. Appearances?
Yes, Your Honor.
Go ahead, Mr. Carter.
Yes, Your Honor.
State your name again, sir.
David Carter, Your Honor.
All right. Counsel?
Maxfield Muda on behalf of plaintiff, Your Honor. We do have a consent judgment on this one. We've got a rent to retain in the amount of $2,400.56. Court costs in the amount of $179, giving us our grand total here today of $2,579.56. In paragraph 10, we indicate that June's rent was included in the balance so that we could provide an extended payment plan on this matter. We've got a payment plan that indicates defendants to pay $1,000 on or before June 10th, with the remaining balance due and owing on or before June 20th of 2025. If paid timely, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from Mr. Carter to add his signature to this resolution. We did go over MCR 4.201J.
So the balance is 2,579.56. He has to pay the 1,000 by June 10th and the balance by June 20th. True?
Correct, Your Honor.
Do you understand that, sir? So long as you make those payments?
Yes, Your Honor.
Plaintiff, nothing insofar as the judgment is concerned, and you can stay in the property. In the case, he will then dismiss. If you don't pay up on both of those occasions and those respective amounts, you're going to have to vacate. If you don't, you're going to be evicted. Do you understand that?
Yes, Your Honor.
You have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, Your Honor.
Any questions?
No, Your Honor.
Okay, I wish you well. And again, he has your permission to sign your name, right?
Yes, Your Honor.
You're all set. Have a great day. Good luck to you. Robert Johnson, South Point versus Robert Johnson, 2501665. Everybody's name?
Robert Johnson, present.
And Maxfield Muda on behalf of plaintiff, Your Honor. We've got a consent judgment on this one. Rent to retain being $1,773.85. Court cost amount of $179, giving us our grand total here today, $1,952.85. Providing until May 31st of 2025 to either pay that balance or vacate the property. We've got language in paragraph 10, my standard of, if paid timely, parties agree to stipulate, set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from Mr. Johnson to add his signature to this resolution. And we did go over MCR 4.201J.
And again, all these late fees are limited to $70. You've made sure of that for me, right?
So it's the same client. In the previous matter that you asked on, it was a $50 late fee. I'm doing the check on this one as well.
Mr. Johnson, do you understand everything he has said to me today?
Yes, sir.
He tells me that you owe a balance of $1952.85 and that you are agreeing to pay that by May the 31st and allowing him to sign your name to the proposed consent judgment. So long as you make that payment, you'll owe the plaintiff nothing. Insofar as this judgment is concerned, you can stay in the property. If you miss and do not vacate, then you're going to be evicted. You have 3 business days, since you're unrepresented by a lawyer, to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal this. Do you understand that?
Yes, sir.
Any questions?
No, sir.
All right, Mr. Mudar, so everything's limited to 70. You've made sure of that for me, right?
Your Honor, on this one, there's a $100 late fee.
I cannot, they're gonna drive me crazy over there. I'm gonna get really upset with them if they keep doing that. I've told your office a multitude of times, I raised it from 50 to 70. You back all those out before you send me these judgments. You understand?
Understood, Your Honor. I'll make the correction on each individual one, dropping it down to 70, removing the difference, and making sure that's corrected for you.
Thank you very much. I think that's it for you, right?
Yes, Your Honor.
Have a good day. Please make sure that they don't come in and ask me for 100, okay? Thanks.
I understand, Your Honor.
All right, look, everybody's been patient, but I got to get off this bench for 5 minutes. So I will be back here in about 7 or 8 minutes. Thank you.
Thompson?
Did you? All right, staff have all been patient here. I'm doing the best I can. Brownstown Square versus Patricia Thompson. 2501681. Come on, ma'am.
Good morning.
Patricia Thompson?
Yeah, on behalf of plaintiff.
This is on the landlord-tenant case.
Yes.
I need you to start your video, ma'am.
Okay, I'm sorry. I'm trying to get it on. 1 second. There, is that it?
No.
Okay, there.
Your name?
Patricia Thompson?
Did you listen to and understand the rights on the video?
Yes, I did.
You wish to speak to a lawyer?
I'm sorry?
Do you wish to speak to a lawyer?
No, no,
Do you intend to apply for funding?
no.
Counsel, your appearance.
Good morning, Your Honor. Donald Osinski on behalf of plaintiff.
Just give me the total balance. I don't need breakdown, but no more late fees than $70 a month, okay?
Yes, Your Honor. Both of my clients this morning do charge late fees in the amount of $50. I did check the ledgers prior to. The rent to retain inclusive of court costs for Ms. Thompson is $2,299.79.
May I speak, Your Honor?
Do you owe that much?
I don't know what the costs are.
Well,
I owe,
what's the breakdown, counsel? Give me the rent first.
Yes, Your Honor. Rent to retain is $2,110. Court cost in the amount of $189.79 for a total due and owing today of $2,299.79.
Your Honor?
Yes, ma'am.
I have on my paperwork that I was served, I owe $980 for April, $880 for May. They do charge $75 of late fees. So I figured that in, and that comes to a total of $1,935. And I just didn't know what the court costs were.
You said the rental rate was $880 per month.
That's correct. And I owed, if you look at the actual complaint, you'll see that the amount owing was $980. And that's
April 23.
Pardon me?
As of April 23. Tell me how much you think you owe, ma'am.
I owed them $100. And then
I need to know a total amount that you think you owe. Total.
$1,935, but that doesn't include the costs, court costs.
So you guys are off about $200 or $175, it looks like. How do you get to that? Counsel, I'm going to put you in a breakout room with her.
Yes, sir.
Is Lasagna Humphrey here too, Jennifer?
No, Your Honor. All of his other cases he has this morning, I have not had defendants check in.
All right, so I've only got 2 cases left here. Do I have other complexes? I got other complexes?
Yes, he has Truman Estates, and he had 2 cases, and neither defendant has checked in.
All right, counsel, go ahead and talk to her in a breakout room. I'll come back and take care of these, okay?
Yes, Your Honor. Thank you so much.
Thank you.
Jeez. Hamptons versus Derek Brooks, 2501578. Sorry about this. Busy today. Ms. Boston, your name?
Rebecca Austin for plaintiff, Your Honor.
Is Derek Brooks here?
We're going to discuss this case. I'm sorry. He paid in full this morning.
Case dismissed. Motion to plaintiff. Perfect. All right. Now I have Hamptons versus Jessica Cole, 2501582.
Good morning again, Your Honor. Rebecca Austin for plaintiff. Again, we are going to dismiss this. She paid in full this morning.
Case dismissed. Motion to plaintiff. Good. All right. Tanglewood versus Braylon Calhoun, 2501601.
Good morning, Your Honor. Rebecca Austin for plaintiff. I did speak with Miss Calhoun about an hour ago. I don't know where she left the court.
Yeah, she's been in and out a couple times, Judge.
Well, what's she doing? I mean, it looks like she logged off before you could place her in a breakout room on May 5th.
I think she said she wanted to speak with an attorney last time, so you gave her an adjourned date. I did speak with her this morning. We have a consent judgment, and I gave her the 30th to pay. I don't know if I can put those proofs on the record. I'm giving her more time than the 10 days.
She disappeared again, Jennifer?
Judge, every time she comes into the waiting room, I admit her and then she disappears. So I'm not sure. Oh, there she is. It just popped up.
Ms. Calhoun, you have to start your video and state your name. Come on. I got too many people waiting. Ms. Calhoun, start your video.
Good morning.
Okay, stay right there. You're not in a moving vehicle, right? Ms. Calhoun.
No,
you're
it's
not-
parked.
Okay. Why don't you take your glasses off, your sunglasses, so I can see you, please? Now, tell me your name. Tell me your name.
Braylon Calhoun.
All right, now, if you disappear this time, you're gonna have to come up to the courthouse, okay? So just stay right there. She's gonna put proofs on the record. She tells me you guys have a consent judgment, so go ahead with it, Ms. Austin.
Yep, I have passed through running about $885.54. There's $150 late fee for May for a total of $935.54. Court cost of $176.54. Total judgment $1,112.08. And Ms. Calhoun is going to pay that by May 30th. And she did give me permission to sign her name to the judgment.
Is that true, Ms. Calhoun?
Yes, sir.
You agree that you owe that amount? You understand that you have, since you're unrepresented by a lawyer, 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. And if you pay this amount, you can stay in the property. If you don't, then you have to vacate. And if you don't, then you're going to be evicted. Do you understand that?
Yes, I do.
All right. So just pay by May 30th. And you're all set. Anything else, Ms. Austin?
Oh, Your Honor, have a great day.
That's it? Thank you very much. You too. Thank you. It's been crazy here. Good luck, ma'am. Truman Estates.
Thank you.
Truman Estates versus Michael Paisano, 2501679.
Your Honor, counsel's in with Miss Thompson on those. Those are the other ones we got to recall once he comes back. They're no shows.
Anything else? Any other landlord tenant?
Yes, it would be Preston Point.
Where's Preston Point at? I need Preston Point. Preston Point versus, Mr. DeRozak, sorry about this. Marquisha Monroe, 2501703. Ms. Monroe, your name? Okay, stay right there. I'm afraid we're gonna lose you because I'm not getting a good connection right now. Did you listen to and understand all the rights on the video, ma'am?
Yeah.
Do you intend to speak to a lawyer? Would you like to speak to a lawyer? And do you intend to apply for funding?
I apply for funding.
What, have you heard back?
I just got back today, so they want me to upload the judgment that I got.
I can't hear you, ma'am. I can't understand a word you're saying.
Can you hear me now?
A little bit better, yes.
Oh, okay, so I gave them a call this morning. They want me to upload the judgment form for court today, showing the amount owed.
You don't need to have a judgment form. Here's what I'm doing. I'm adjourning this to May 29th. You have 5 days. 5 days to bring in the proof that you've made an application for funding. 5 days. So you have to bring that up to the courthouse, and then that'll get you an adjournment to May 29th. Jennifer, at what time?
1 p.m.
At 1 p.m. So you have 5 days to bring that up here. And then May 29th, you're going to come up here. I want you to come up because we're not getting a good, I mean, it doesn't seem like it. I mean, if you want to do it from there and we get a good connection, fine, but be prepared if we don't to have to drive up here, okay?
Okay.
All right, May 29th at 1. Thank you. Preston Point versus Tuakari Moore, 2501704. Good morning, ma'am. Your name?
Good morning, Takari Moore.
All right. Did you listen to the rights and understand the rights?
Yes, indeed.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Mr. Drozak, your appearance?
Good morning, Your Honor. Mike DeRosak on behalf of the plaintiff, Preston Point. Your Honor, presently there is rent retained possession owing in the amount of $3,603. Late fees totaling $150. That's 3 months.
By the way, I've increased that to 70, just so you know. I don't know if you've been in here. I'm 70 a month, but if it's 50, that's fine. 150, and then what do you have in costs?
I have $249 in costs, Your Honor. The total we have at this time is $4,002 that is owing.
And you're asking for a writ date of the 27th?
That's correct, Your Honor.
And can you pay that?
Not the whole 4,200. Actually, I have not currently lived there.
I gotta have you get closer to your device. I'm having a strain here to hear you.
I'm very sorry. Can you hear me better?
Yes.
I currently have not lived there for almost 7 months. I actually got the summons from my ex. I actually emailed and called up there November, I want to say the 15th, to say that I wanted my name off the lease and that I was just with my ex.
Wait a second. Can you tell me why you're walking around? Would you please stop? Just stay in the same location so I can hear you.
I have my daughter next to me. She's kind of talking and trying to get near me, so I'm trying to get away from her. I'm sorry. Give me 1 second. I have not. So I actually moved out almost 7 months ago.
Did you turn over the keys?
I'm sorry. Yes, I gave them to my ex. I did not give them to the office building, but I have realized that he has not been paying and that the amount that is owed is still owed. I was hoping to get a monthly payment with me and him to be able to pay off the total amount that is due.
You're not living there anymore, right?
No.
Counsel, did you seek a money judgment?
We do have a money judgment. It looks like service was by posting. Obviously, she's not there. She probably was not personally served. We have no problem taking a possession-only judgment on this.
The person that was, and my ex that was on the leasing as well, Kyle Ellis, he has stated that he is, I guess he was unemployed for a moment and was not paying rent, and then moved back. I guess he emailed.
Well, you got to be careful. If you're on a lease, you're subject to paying on this. You got to be careful. You can't just turn the key to your ex-husband or ex-boyfriend or whatever it
Yes,
was.
Your Honor. But if we could get a certain amount set, he would like to pay that monthly to get the total amount paid off.
Well, where's he at? Wait.
As my knowledge, he currently still is resigning in there.
You're Takari though, right? You're
Yes, I am Takari Moore.
Did they not sue him, Mr. DeRozak?
It
No,
looks
they-
like this is an all occupants case, Your Honor. So, I mean, he would be subject to the possession judgment. It sounds like he is
I
aware
got
of
it.
it.
I got it. Okay. Well, you could have saved yourself. I don't know how long he's been there. I mean, I can give Mr. DeRozak a judgment. He's only asking for possession right now. And then you guys can call up and talk to him about setting up a payment plan to satisfy any potential money damage.
Okay.
Is that acceptable to you, Mr. DeRozak?
That is, Your Honor. Would you like me to submit the judgment form by hearing?
Yes, via hearing, and the writ date will be on May the 27th. So everybody has to be out of there by May the 27th, Ms. Moore, okay?
So I'm just gonna write this down so I can give it to his mother because she is the one who gave me the summons. You said by May 27th,
Correct.
everything needs to be out
Correct. And the
And-
keys turned over.
and keys turned over.
Okay?
And then who shall I be calling just so that in case that there is any payments still needed to be paid after
You
that?
can call that number on all your paperwork and ask for this gentleman, Mr. DeRozak, DOROCAK.
Thank you.
Thank you. Good luck to you.
Appreciated, Your Honor. Have a nice day.
You too. Preston Point versus Harley Stevens. 2501705. Ms. Stevens, your name?
Harley Stevens.
Did you listen to and understand the rights?
Yes, sir.
Do you intend to speak to a lawyer?
I was hoping I could.
All right. We're going to adjourn this one a week, Mr. DeRozak. We'll give you the 20. What day is it, Lisa or Jennifer?
The 19th.
So we're going to she's going to chat with you and give you that number, and you have to take care of that real quick, okay?
Okay.
All right. So she'll send you that info when you call that Lakeshore, but call today right when you get off the Zoom call here, okay?
Okay, thank you so much.
Thank you. Good luck. Thanks,
Judge,
Mr.
what is that adjourn date? Do we know? Or will
May
we get
19th. I'm going to make it on Monday, I guess.
Okay.
At 10:30.
10:30.
Thank you.
Thank you. Brownstown Square versus Lasagna Humphrey, 2501682. Everybody's name.
Good afternoon, Your Honor. Donald Osinski on behalf of plaintiff.
And she is the one who's not here, right?
That's correct.
You can go ahead and take a default on this one.
Yes, Your Honor. Thank you, Your Honor. I am showing rent to retain as $1,025 for cost in the amount of $189.79 for a total due and owing today of $1,214.79. We'd like to request a writ date of May 27th.
Default judgments entered in favor of plaintiff and against defendant. Writ date will be the 27th of May. The amount to be paid to save it is $1214.79. The case is scheduled for 10:30. Defendant neglected to show. Brownstown Square versus Patricia Thompson, 2501681. Everybody's name again, please.
Good afternoon, Your Honor. Donald Osinski on behalf of plaintiff.
And I'm Patricia Thompson.
Okay, go ahead, counsel.
Thank you, Your Honor. At this time, we would like to just request a 2-week adjournment until if the court has available May 29th or the week of the 26th.
Yeah, we'll adjourn it. Adjourn to May 29th. Is that what it is, Jen?
Yes, Your Honor, and we're due 1:30.
At 1:30. May 29th at 1:30. That's 2 weeks from today, folks. We'll see you here then.
Thank you.
I think I've got everything done with landlord tenant, right?
Truman
Estates, Your Honor. There's 2 of them and they're both defaults.
Truman Estates versus Michael Paisano, 2501679. Counsel?
Good afternoon, Your Honor. Donald Osinski on behalf of plaintiff.
You can go ahead and proceed with your default. Defendant failed to appear and there was a second mailing.
Thank you, Your Honor. With the defendant failing to appear, plaintiff would like to request a default judgment in the matter. I am showing rent to retain as $960. Court costs in the amount of $184.17 for a total due and owing today of $1,144.17. We'd like to request a pay or move out date of May 27th.
Defendant failed to appear. The writ date will be May 27th. Defendant is in default. Default judgment's entered with the amount to be paid to save it is $1144.17. Truman versus Jason Adams, 2501-680. Appearance again.
Good afternoon, Your Honor. Donald Osinski on behalf of plaintiff.
Okay, you can go ahead and proceed with your default.
Thank you, Your Honor. With the non-appearance of the defendant, plaintiff would like to request a default judgment in the matter. I am showing rent to retain as $2,600. Court cost in the amount of $184.17 for a total due and owing today of $2,784.17. We'd like to request a writ date of May 27th.
Defendant is in default. Default judgment's entered. Writ date will be May 27th. 2078417 is the amount to be paid to save it from the issuance of the writ. So that should be good for all those. Thank you very much. Have a good day. Jacob Christopher Less now, 24F242298. Do I have somebody on this one?
Right to the podium.
Name? Charges failure to submit to testing 3 times per month is ordered on May 6th of 25. If you plead guilty or if you're found guilty, you have no prior technical violations. That would be the first, and you could get 5 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice to rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes, sir.
To the charge, you failed to submit the 3 times per month testing is ordered on May 6th of 25. How do you plead?
Guilty.
Did you fail to submit the testing on that day?
Yes, sir.
Why?
So I've been going out of town for work trips a lot, and I've been really communicative with Ms. Tessino, letting her know. The first, we were supposed to have a meeting. We ended up getting a Zoom meeting. She just applied me for early discharge or dismissal. And then I also tested that day first, so I'm like, okay. Since we didn't have the Zoom meeting, I completely forgot to bring up my work trip. I just went to South Bend, just like 3 hours drive. So I missed testing the 6th, I think it was. And that was my fault. It was just lack of communication and won't have.
Let me call in Ms. Tessino. Have a seat a second, okay? People against? Grace, Ada, I'm so sorry on this. Keckerell, 25F243909.
Michael Cross, representing the defendant on the letter, state her name for the record.
All right. I'm entering a not guilty plea. She's going to plead to allowing unlicensed to drive. They're going to dismiss the expired license, right?
Correct.
Ma'am, if you do that, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes, Your
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
To the charge of allowing an unlicensed driver to drive, how do you plead?
Yes, Your Honor.
On the 3rd day of 25, were you in control of a 2018 Ford that was being operated on Telegraph near Law and Flat Rock?
Yes, Your Honor.
And did you allow somebody to drive that was unlicensed and was that you?
Yes, Your Honor.
Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accept it. Did she ever take care of her expired license?
Yes, Your Honor.
You've done that?
Yes.
You have it now?
Yes, actually.
She showed me the temporary, she would put the physical come to
Okay. What do you want to do?
So, Your Honor, my client feels terrible about this matter. She was just going through a really tough personal time and just missed the deadline, and she just got behind on because it let it get expired.
Good
She's
enough.
already stated she's already called up, Your Honor. She won't do it again. But we'd like the court to take consideration that she's in between work right now. She does some odds and ends on the side to kind of make it. So we're going to be asking for a payment arrangement. But any consideration she'd appreciate.
Anything?
Yes, that would be nice if it can be considered my payment plan.
20 fines. And I'm doing this because it's just expired license. I mean, 20 fines, 20 costs, 75, she's got a good record for the most part. 75 victims' rights, $50 justice assessment, 165 or 30 days. She's got no misdemeanor anywhere on her record. How much can you pay today? Anything or
I
not?
have anything today.
Pay 40 a week and I'll start you on May the 30. How's that?
Yeah, that's what I spoke earlier with, and then on 30th, I can pay that.
$40 a week then?
Did you say weekly?
Yeah.
$40 weekly?
She was hoping to pay $50 a month or
At least two.
Why aren't you working? Why aren't you working?
I am actually looking for jobs right now, and I've been sending a lot of applications. I did have an interview.
I'm gonna let you pay $40 a week starting June the 13th, okay? If you don't have the money on any one of the due dates, you come talk to me. I'll be happy to give you an extension. All right, I wish you well. Good luck. Thank you, Mr. Crawford. Let me just see this. Yeah. Well, I'm kind of getting worn out here. Do you have Rich?
I do.
Andrea, Danielle, Rich, 25F243816. Everybody's name here.
One year under my co-property representation was approaching. State your name, ma'am.
Andrea Rich.
So she stands me a wage formal rating?
Correct.
Now she's going to plead to impaired driving with the OWI to be dismissed, true?
True.
Is that what you want to do?
Yes.
If you do that, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read and understand the rights?
Yes.
If you plead guilty, you're giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
The charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle in the city of Flat Rock, county of Wayne, state of Michigan on April 13 at 25 at 2:56 in the morning?
Yes, sir.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
It's like around about like 6 tequila shots, perhaps.
And why were you pulled over by the police?
They said that I did not merge lanes without a turn signal, but I think it's because the vehicle is, like the plate and insurance is through my uncle who is.
Do you think you did anything wrong in the operation of the vehicle?
Honestly, no, I don't think that I did. I think that they read the plate because I've gotten pulled over for it before, randomly throughout the night. And they thought I was Christopher, which is my uncle, who is facing criminal charges.
There's a random pull over?
Yeah, they do that all the time because he's on the run and they think that they're gonna find him. I've gotten pulled over. I think.
Hang on a second. Slow down. Just slow down.
Yeah, sorry.
Slow.
Yeah, sorry.
Take your time. How much did you have to drink?
You gotta
take that phone out of the courtroom.
Phone's got to go out of the building.
No. I'm sorry.
Around like 6 or 7, I believe so. Like I can't recall.
Slow down.
Perfectly.
Ma'am.
Sorry, I'm stressed. Around 6 or 7.
Don't be stressed. I have concerns here. You're not even 21, right?
Yeah, I'm
You're
aware.
not even legally able to drink, right?
I'm aware.
And you went out and got over a 2-0, right? Right, Mr. Crawford?
Yes.
So I'm only telling you that's a big red flag. Hang on. People that come in here that are not capable or able to drink yet, that come in with these kind of breathalyzer or blood draw results, usually come back to see me or another judge. I know I've never had anybody say I'm coming back. I want you to be aware of that. 30 plus years, not one person when I've said that kind of thing has ever said, I'm coming back anyways. I'm going to make sure I get in trouble. Everybody says, oh, you'll never see me here again. Well, guess how many people I see again? I'm telling you. Counsel, do you stipulate that this, for purposes of this plea, was an accurate reading? Did you feel, and it's 0.197 actually, right? Do you believe you were intoxicated?
I'm
asking you a question.
I mean, of course, I think so. I'm not sure what to say.
Well, the truth.
Told me.
Yes.
Was your ability to operate the car visibly impaired?
Yes, it was.
Also,
Because I really could, my vision was very poor at that moment in time.
Okay. Okay, but did you feel intoxicated? Or did you feel perfectly normal like you do right now?
Slightly, I can't recall, perfectly, I don't wanna state something that is inaccurate.
Well, I don't want you to say anything that's inaccurate either. This was only a month ago, though.
I know, and I have a lot of mental health issues.
Okay,
so
just relax.
It caused me to not
Listen.
be able to.
Just take a deep breath, please, and just relax.
Yeah, I'm trying. It's
Okay.
scary.
Well, I don't want you to be scared,
I know.
okay? You think you shouldn't have driven the car after having all those tequila shots?
Of course not, no.
Okay, all right. And counsel, again, you stipulate that that was an accurate reading, right?
So stipulated.
Ma'am, are you on probation or parole?
No, I'm not.
Anybody force you to plead guilty?
No, sir.
Do you work?
Yes, I do.
Where?
I work at SOS, which is Success on the Spectrum. I'm a behavioral technician.
Okay, just relax. I have real concerns here, though. I'm just telling you, and I'm not trying to make you feel bad. When I see somebody under 21 with basically a 2-0, they got a problem going on. Most people would be vomiting long before that.
Oh,
I'm just telling you. You can believe me, not believe me. It's okay. I'm gonna accept your plea to impaired driving. Nobody's forced you to plead here, have they?
No.
Accept your plea to impaired driving, dismiss the OWI, refer you for screening and assessment, $1,000 personal bond. I want you to go on. First of all, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you to go to AANA at least twice a week. We're going to give you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you.
Okay.
I'm concerned about you. I really want to order a SoberLink device. I think I'm going to. How much do you make in your employment?
Right now, because I had gone part-time,
I just need to know how much you're making.
maybe $700 every 2 weeks.
Do you live at home with your parents or anything? Or?
I live with my father.
I want you on a SoberLink device by the end of the day. You're going to have to figure out a way to come up with the money, okay?
How much is
They're
that?
going to explain it. They're going to explain it in the probation department. How much is it again?
It's a $50 enrollment fee, and then it's $6.50 a day. She'll have to pay 10 days up front.
So you have to pay 65 plus 15 right up front.
50.
For how long? Because I can't remember that.
Hang on. Listen, just relax. I know, but it's 65 for 10 days plus the 50. And maybe I misspoke. I meant to say it's 115 for the 10 days. And then she's going to have to pay $6.50 a day.
I'll put her on a payment. They work with people.
Yeah, you're going to have to get it by the end of the day, and probation's going to meet with you. I'm ordering a screening and assessment. We're giving you the AA verification sheet. You have to go. You have to have the form signed. Let's nip this in the bud before it becomes a big problem,
It's
okay?
never going to be a problem, and it isn't.
Ma'am?
This was just.
I know you don't want to believe me. I know you don't want to believe me, but I've been here at least 10 years longer than you've been alive. I've seen this video before. And nobody wants to believe me. They think I make up stories up here? I'm telling you, when people drink enough to get drunk drivings before they turn 21, the great majority are coming back to see us. It might be domestic violence. It might be drugs. It might be retail fraud. It might be another drunk driving. They're coming back to see us. I hope you don't. I know. I'm only telling you, I've never seen anybody come in here and say, Judge, you're right, I'm coming back. I can't wait till I get drunk again. Listen, we're putting you on the SoberLink device. You gotta be on it by the end of the day.
And how long does that last?
I don't know. I'll worry about that at sentencing. We doing May 19th on this? I mean, May 29th?
Yeah, May 29th, 8:30.
At 8:30, okay? May 29th at 8:30, I'll revisit this with.
How do I find?
You're gonna talk to probation. You're gonna go over down the hall, get your notice. Wait a minute, wait, don't walk away from me. You gotta just chill out a second here. Chill out. You're gonna go down the hall and get your notice, and then you're going over to probation. You're gonna fill out a question and be interviewed, and they're gonna talk to you about how to go about getting that sober, okay? Do you understand all that?
Yes, thank you.
Thank you. Jacob Christopher Lesnow, 245-242298. Your name?
Jacob Lesnow.
Tell her what you said to me.
That's what we talked about in the email. Like, we were gonna have a game. I completely forgot to bring it up to you.
Keep your voice up.
I tested that day as well. And then I went to the South Bend.
Why'd you go to South Bend?
Work trip.
What kind of work trip?
Aviation.
Okay. I thought you were going to cheer for Notre Dame football or something. I didn't.
Email.
Huh? Okay.
I have proof of the work trip. The issue is, so it's kind of like deja vu. I applied him for early discharge May 1st. We were supposed to meet that day. I told him he didn't have to appear. I emailed him back, told him I applied for early discharge and to make sure he checked for black and continued to test. So he left on this work trip that he went on without permission. His caller was called again, and this was on, what day of the week was that?
Why'd you do that? You didn't get
And
permission
then
to
he
leave the
wasn't gonna
state?
be able to test until Monday.
Did I give you permission to leave the state without consent?
That was my fault. I did not happen again. It has not happened after.
And I have worked with him on work
Settle
trips
down a
and
second. What are we gonna do on him? So he's not eligible for early discharge.
again,
What's that?
again, this is the second time we've done this. I feel like I'm having deja vu.
Why are you doing this?
It was a mistake. It slipped my mind. I was supposed to bring it up to her. It's just a lack of communication. Just got a lot going on. I'm sorry.
What's going on? What's a lot going on? Tell me.
Just work and just stressing about stuff I don't need to, just family issues and stuff like that, but that's no excuse.
Everybody's stressing about things.
Yeah.
We all stress about things.
Yeah.
So now he's stuck on probation a while longer.
Well, if you remember, what had happened was he was here for a violation. He was found not guilty. It was dismissed. So he told me I could apply him for early discharge again May 1st.
Jeez.
So you did the 3 times a month testing. And then we have kind of another dilemma that I want to make sure we just address everything while he's here. He booked a trip for next week. It's his sister's wedding, so I don't really know how to handle that either.
I canceled the flights right now because I don't know how this is going to go, just to make sure I got my money back. But yeah.
Where's your sister getting married?
Florida.
Nobody wants you to not be able to go to your own sister's wedding.
Yeah.
What am I gonna do with some, I mean, problems are created that don't need to
And
be
he went
created.
through the whole, I mean.
Has he been, did he do everything else
He did
right?
everything else. He honestly did everything on time. It's just been this last little chunk of early discharge that we're running into problems. And then
He never tested positive, did he?
so he was the one, if you remember, he tested positive on an instant cup, admitted to drinking, but the lab came back negative. So you ended up dismissing it, why?
Yeah, because he was on.
Because he was honest, correct. So we put him on the sober link for a trip he had for work. He turned that in and he's been testing 3 times a month. His last test I have is May 1st, that is negative, and then he hasn't tested.
Yeah, I just can't, I'm sorry. I'm gonna accept your plea, if you still wanna plead, to failure to test. You did plead to that, right? Yes? I'll take your plea. I'm not gonna do much, but you Pay attention to what you're doing, please.
Yes, sir. I'm sorry.
I mean, I gave you a break last time. The additional cost of $100, perform 6 hours of community service by June 7th. So you get on that, okay?
Yes, sir.
And then we're gonna be done with it hopefully soon.
Can I ask you a question?
You sure
Do you want
can.
to continue on 3 times a month?
Now I'll reduce his testing to bi-weekly, okay?
And then can you go on the trip?
Yeah, you can go on the trip. I don't want him to miss his sister's wedding.
Thank you, sir.
When are you going?
I can book it, well, I'm gonna book it for Saturday again.
Boy, you kind of panicked.
Yeah.
You think we're ogres over here? Don't answer that.
Well,
I'm just kidding.
Yeah.
You can leave your state to go to Florida. When you gonna be there again?
The 17th.
All right. Between the 17th and what?
25th.
All right. Have a good time. Congratulate your sister for us, okay?
Thank you, sir.
Good luck. So you got to pay that little bit of money and
$100 and 6 hours of community service.
yes, you're all set. Good luck.
Thank you, sir.
Johnson Glover. Julian Enrique Johnson Glover, 25F243480.
Good afternoon, Judge Mannigan, and Mr. Glover.
It's been a busy day, guys. You've done a good job here today. Sir, I was talking about the lawyers. Your name?
Johnson Glover.
All right, how are we doing, Mr. Glover? He's going to plead now to operating, well, first, he has not been arraigned.
We'll stand in the agreement.
All right, so I'm entering a not guilty plea. He's going to plead to operating while impaired, the OWI to be dismissed, right? Is that what you want to do, sir?
Yes.
If you plead to that, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, the charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on April 5 of 25 at 12:02 a.m. on Telegraph near Gibraltar and Flat Rock?
Yes.
And did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, I did drink. I had like 3 shots in a day.
Why were you pulled over by the police?
He told me that I was too close to the driver in front of me.
You think you were tailgating a bit?
Yes.
And did you take a breathalyzer or blood test?
Breathalyzer.
Counsel, were the results 0.09?
0.095.
And you so stipulate that that was an accurate reading?
Yes.
Are you on probation or parole, Mr. Johnson Glover?
No, Your Honor.
Anybody in the world force should plead guilty.
No, Your Honor.
Please accept it to impaired driving. The OWI is dismissed. I'm referring you for a screening and assessment. You're going to be screened today, fill out a questionnaire, and be interviewed today, and then you'll come back for sentencing. I'm going to give you a personal bond, $500. I'm not going to order no alcohol, no marijuana, no illegal drugs. It's a first offense. You cannot leave the state without the consent of the court or violate any law, and you must appear in court as directed. I'm going to give you May the 29th, right, Lisa?
Yep, 8:30.
At 8:30 in the morning, okay?
Yes, Your Honor.
So you go down the hall, get your notice, then go over across the hall to probation, and you'll fill out a questionnaire and be interviewed, okay?
Thank you, Your Honor.
Best of luck to you. Thank you very much. Rodriguez, Jonathan Rodriguez, file 25F24 3935. Your name?
Jonathan Rodriguez.
All right.
Good afternoon, Judge Mannigan.
We're adjourning this, right?
Yes, for clearance.
Yeah, so I'll give you 4 weeks. It's about the best I'm gonna do, though. What can you give me, Lisa?
June 12th at 8:45.
June 12th at 8:45, okay? Sir, June 12th at 8:45. You're gonna go down the hall and get your notice. Sir, would you talk to me instead of your lawyer? June 12th at 8:45. If you want a lawyer going forward, you're gonna have to fill out a petition for one. You go down the hall and get your notice, okay? Best of luck. Thank you. So if you want a lawyer, fill out a petition there. Caitlin Busby, 25F243696.
Good morning, good afternoon, Judge Cassidy, and Ms. Busby.
Ma'am, your name?
Caitlin Busby.
All right, so she's standing mute, waiting for formal reading, right?
Yes.
This is a noise violation.
Correct. But there's some other underlying issues, so.
I got it, that's fine. You cannot leave the state without, I'm gonna give you a personal bond, $100. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, starting with May the 29th. We'll make that at
9 o'clock.
9 o'clock in the morning. So you can fill out a petition for a court-appointed lawyer as well, right there at the table, and then you hand it in to my court officer, okay? Any questions, ma'am? Any questions, ma'am?
No, you're.
Good luck. Counsel, did you figure out these alcohol, tobacco cases?
Yes, the ones that we're doing, Your Honor, they have an alcohol and a tobacco. We're dismissing the tobacco and doing the 771 on the alcohol.
I got it. Because you didn't
I
update
tried to catch that guy before.
you didn't update your ordinance then.
No, I got updated. I tried to catch the defendant that.
I got
it. And I couldn't get him in time.
I got it. All right, Curtis Amati, 25R513-926A and B.
Good morning, good afternoon, Judge.
Just let me know, Brandon.
I'm ready.
Okay.
All right, sir, your name again?
Curtis Brandon.
Counsel, for purposes of arraignment, does he stand mute and waive formal reading?
Yes, sir.
And so now he's going to plead guilty to operating while impaired with the OWI to be dismissed, correct?
Correct, Judge. There's also a B file that's going to be dismissed over as well.
And that charge is resist, hinder, and obstruct an officer, right?
Correct.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead guilty to operating while impaired, I'm going to dismiss the OWI. I'm going to dismiss the resist and obstruct. The possible penalties on the impaired are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all those 4 points. A license suspension or revocation in accordance with your record, your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
Did you sign, read, and understand an advice of rights form here today?
Yes, I did.
If you plead guilty, you'll be giving up all those rights and there won't not be a trial. Do you understand that?
Yes, Your Honor.
Any questions?
No, Your Honor.
We charge operating while impaired, are you plead?
Guilty.
We operating a motor vehicle in Huron River Drive near I-75 in Rockwood, March 17 to 25 at 9:40 in the evening.
Yes, I will.
Did you drink alcohol before that? If so, what did you drink and how much?
I did. I drank approximately 4 or 5 beers.
And was your ability to operate the vehicle impaired because of that?
Yes,
Why were you pulled over by the police?
I was speeding.
You think you were speeding at least in part because of your alcohol consumption? Did you take a breathalyzer test at the police station?
I took one on the scene.
I know, but at the police station too, or was it a blood draw?
It was a blood draw.
And counsel, something where here I just saw it.
I believe it was between 1 and 2.
Do you stipulate that was accurate for purposes of the plea?
I do.
Are you on probation or parole right now?
No.
Anybody in this world force you to plead guilty?
No, Your Honor.
Please accept it, operating while impaired. $500 personal bond. The OWI is dismissed. I'm referring you for a screening and assessment. No alcohol, no marijuana, no illegal drugs. Those are your bond conditions, okay?
Yes, Your
So I'm dismissing the the OWI, accepting the plea to impaired, no alcohol, no marijuana, no illegal drugs. You cannot leave the state without consent or violate a law. You must appear in court as directed. You understand all that?
Yes, sir.
Any questions?
No, Your Honor.
Okay. So you're going to go down the hall, get your notice. We're going to give you a date of what is this again? Maybe we want to move this one a little, Lisa.
June 12th at 8:30.
June 12th at 8:30. And then you go down the hall, get your notice, and go over across the hall to probation where you're going to fill out a questionnaire and be interviewed. Again, I'm dismissing the R&O case and the OWI case.
Thank you. Thank you.
Anything else?
Nothing else, sir. Thank you.
Good luck.
Thank you.
Go. Ron Sheena. Ron Sheena. Is this yours too?
Yes. At that.
25R514-107A and B.
Good morning, good afternoon, Judge Mezigan, here back in Sheena.
Sir, your name?
Ron Sheena.
He's gonna plead to furnishing an alcohol to a minor, right?
Correct, yes.
And that's gonna be taken under section 771.1 for 6 months, right?
Correct.
And then in return, prosecution is going to dismiss the furnishing tobacco to a minor, right?
Correct.
All right. Your name?
James Allen, on behalf of the city of Rockland.
I got the book back there, but wherever, that's 500 in fines and 90 days jail, correct? On the furnishing alcohol, or is it not?
Yes, up to.
Do you understand that, Mr. Sheena?
Yes, I do.
If you plead guilty to that, those are the possible penalties. I didn't say I'm gonna do that. I'm just telling you the maximum penalties are up to 500 fines, 90 days jail, costs are all those. If you plead to that, I'm gonna take that under section 771.1. I'm gonna place you on probation, set terms and conditions, and if you're compliant at the end of 6 months, your case will be dismissed. You understand that?
Yes, I do.
All right. And again, did you sign, read, and understand the advice of rights?
Yes, I
And
do.
you understand you plead guilty to that charge and dismiss the furnishing tobacco to a minor charge. Do you understand that?
Yes, I do.
All right. You fully understand everything.
Correct.
To the charge furnishing alcohol to a minor, how do you plead?
Guilty.
On April 19 at 25 at 7:27 PM, were you at 32825 Port Street in Rockland?
Yes.
And did you furnish alcohol to a youngster that was less than 21?
Yes, I did.
You didn't check their IDs?
No, I did
Why
not.
not?
Your Honor, we were really busy that day. It was
I know, but
Easter.
one of those kids go out and kill somebody after they're drinking.
I apologize for that, Your Honor.
I'm just telling you, people are in a lot of trouble if that happens. Are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it. I'm dismissing the tobacco charge. I'm not going to order a pre-sentence report. I'm going to ask you to have a seat, and I'm going to sentence everybody at the same time on that one. People against Jessica Lynn Anaya, 25R5141188 and B. Same thing here, right?
Good afternoon, Judge Mezigan, attorney back in Mr. Knight.
Ma'am, your name?
Jessica Knight.
So she stands mute, waives formal reading on both charges. This will be a plea of furnishing alcohol to a minor with the understanding that once she pleads to that case be taken under section 771.1 and the furnishing tobacco to a minor will be dismissed. True?
Correct.
So same thing, ma'am. If you plead guilty here, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand and advice of rights?
Yes.
You understand you plead guilty? I'll take this under section 771.1. I'll set terms and conditions. And if you're compliant, at the end of 6 months, the case will be dismissed. Do you understand that?
Yes.
All right. You understand everything on the rights form?
Yes.
If you plead guilty, you're giving up those rights. You understand that? Right?
Yes.
To the charge furnishing alcohol to a minor, how do you plead? Were you at 22855 Huron River Drive in the city of Rockwood, County of Wayne on April 19 and 25 at 8:23 PM?
Yes, I was.
What kind of store was that?
It's a Rebel convenience store.
And you sold alcohol, you furnished alcohol to a child, a person that was under 21?
Yes, I did.
Why didn't you check their ID?
Same thing, it was day before Easter, it's really busy. I definitely understand the consequences that the young person can go out.
Yeah, you guys can't do that. Are you on probation or parole?
No,
Anybody forced you to plead guilty?
no.
That please accept file A, file B is dismissed. I'll send you in a couple of minutes if you'll have a seat. People against Portia Thompson, I have 25R5141108A, B, and C.
Good afternoon, Your Honor. Michael Ross, representing Ms. Thompson.
Ma'am, your name?
Trisha Thompson.
She stand mute, wait formal reading?
Yes, Your Honor.
So the B and that's on all files, right?
Correct, Your
The
Honor.
B and C files are to be dismissed. She's going to plead on the A file under 771, right?
Correct, Your Honor.
Is that what you want to do, ma'am?
Yes, Your Honor.
If you do that, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. I'll take it under section 771.1. I'll set terms, and if you're compliant at the end of that specified period, the case will be dismissed. Do you understand that?
Yes, Your
Did
Honor.
you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes, sir.
I can't hear you.
Yes, Your
To
Honor.
the charge furnishing alcohol to a minor, how do you plead?
Guilty.
On April 19 of 25 at 7:50 PM, did you furnish alcohol to a minor at 22401 here on River Drive?
Yes,
That person was 19, correct? You sold them White Claw,
I did, Your Honor.
and did you not look at the ID?
They look familiar. I thought I had served them.
Are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Plea is accepted on file A. B and C are dismissed. Are we ready almost on that, John?
They're zoomed in, yeah.
Okay, I'm gonna recall all these. Why are you guys doing this? Come on up here. I want Tricia Ray Thompson, 25R514-108A. I need probation orders. I dismissed B and C. I also want Anaya. Jessica Lynn Anaya. File number 25R514-118A. I dismissed that 118B file. And also, Ron Sheena, 25R514-107A. I dismissed B. Your name,
Tricia Thompson.
your name,
Jessica.
your name.
Ron Sheena.
Jeez. Who's representing who here?
I'm representing Ms. Thompson.
I represent Ms. Anaya and Mr.
Okay, I need your appearance.
Resident appear on behalf of Ms. Anaya and Mr. Sheena.
Michael Crawford representing Ms. Thompson. This is Thompson.
You guys want to kind of say anything here? I mean, I don't know what to say. I think this is pretty irresponsible, if you want my honest opinion. I'm gonna let your lawyers speak first, okay?
Well, with respect to Ms. Thompson, she agrees that she probably should have took better steps and checked for ID like she normally does. This was a mistake. It won't happen again. She feels terrible. Her husband's in law enforcement. They take it pretty seriously, following the law and speaking around her. She's got a clean record. So learning lessons, very upsetting, but she's gonna get through this and we'll see if this violation again.
And I would reiterate the same thing on behalf of my clients as well. Obviously, Mr. Sheena's been in the business for a while. This is the first offense that he's had, as well as Ms. Anaya has been working in this business for a while as well. Also, this is the first offense for her. Obviously, like they said, it was a busy day. This was an oversight, but obviously they learned a lesson from this incident, and this absolutely will not happen again. They've assured me of that. And Judge, I know that they take it seriously as well, and they would ask the court to take that into consideration.
Just give me 1 second here, please.
Carding more people, anybody that looks under 40, anybody that looks under 35.
Did you card me?
No.
Sorry, I couldn't resist.
And I definitely value the accuracy of checking IDs more than the speed of taking care of customers.
Caught.
OWI before,
What else?
I believe my case was with you.
Well, you got a 1 out of 2 chance to get me. You got warrants all out. Why don't you take care of your warrants?
I have 2 that I'm aware of, that.
What about the driving under the, you had driving under the influence of alcohol in Lincoln Park?
That River Ridge, right? Or-
Well, whatever, the 25th District Court in Lincoln Park.
I was confused about those because I was just incarcerated for 9 months and I did plead by mail to all of those and I'm not understanding why I had.
Did you hear back from the judge? No. If you're married to somebody in law enforcement, you're getting this much trouble, huh?
She's not the one, Judge. It's Ms. Thompson.
I see. What else do you want to say?
I understand it was wrong to sell to a minor. I've lost a child myself, so I would never want to put nobody in that predicament.
Geez, I'm sorry about that.
I did lose my job, so.
I don't want to see you guys again, okay? Mr. Sheena? I mean, I don't know. You know, I hate to pile on here. I think you guys should try to what it's 6 months probation. Did I let everybody finish? Did I let you finish? I just want to make sure I let everybody finish.
Yeah, I've become more diligent. I actually took a Surf State alcohol safety class just to understand how alcohol works properly in the human body. But I have been IDing everybody.
All right. Lisa, I want you to give me a date, please, for a review hearing in 6 months. So all these cases will be dismissed if you're compliant. Okay? So have I let everybody in here finish?
I was just wondering, whatever my fee is, that if I could just get a payment plan. so
Yeah, I
I'm
can
back
do
working.
that. Sure. Anybody else have anything to say? I'm gonna fine you all the same, 6 months probation. I'll make it non-reporting probation. You just have to, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm gonna give you a review hearing date. And, you have to pay probation fees of $120. And I'm gonna go light on the fines, 100 fines, 50 costs, 75 victims' rights, $50 justice assessment. So you're gonna have to pay $395. You pay that, you stay out of trouble, you come back at 6 months, I'll be more than happy to dismiss your case, okay? And that's what I'm gonna do here. Lisa, you're going to give me, and again, it's non-reporting probation. You're gonna give me a review hearing date. We're gonna give you guys a review hearing date. You'll come back and it'll be dismissed. So it's 370, so it's actually 395. Pay that, stay out of trouble, comply with those general terms, come back and get it dismissed, or if you don't, you could serve 90 days. What do you have as a review hearing date, Lisa?
October 29th at 9 o'clock.
10/29 at 9. Okay, folks? Okay, now, before we go on. I want to know if can you pay yours, ma'am? Today?
Not today,
When can you pay this?
tomorrow.
Okay. You can pay by May the 16th. Sir, can you pay yours today?
Yes.
You pay yours today, you'll meet with probation just for general ideas. We're just gonna have to explain a couple things to you. And how about you, Ms. Anaya? When can you pay this? Can you pay $50 a week starting June the 6th? I can't hear you.
Can it be, like 75 a month? I'm just now trying to start back working. I did lose my job because of the incident. So
I'll tell you what, I'll let you start on the 27th of June, okay?
that's fine.
If you don't have the money, you call the court. I'll be happy to give you an extension. We'll go on Zoom. Just don't ignore me, okay? But I promise you, I will give you all the extensions anybody needs. I wish all of you well. Again, you're gonna meet with probation before you leave here, okay? Thank you very much and good luck.
Thank you.
John, make sure I got these right. I got Thompson here. Sheena should have another one. So those three. People against Salamasi. Nicholas Salamasi. 25B710-831. All right. Good morning, Detective. Your name? I guess it's afternoon now. Your name, please?
Good afternoon, Your Honor. Detective Bernal, Brown, please.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
On May 13th, 2025, at approximately 16:46 hours, Officer DuBois was in the areas located at 23007 Telegraph Road, Brownstown, Michigan. Reference to a larceny complaint. As advised that caller stated the suspect, who was described as a white male with red shorts, black shirt, stole an employee's cell phone from within the store prior to fleeing the scene on a bicycle. Officer DuBois responded to the Walgreens while Officer Aguilar's canvas area for the suspect. Victim Murphy is a Walgreens employee. Victim Murphy stated she set her phone down on a cart while preparing to take out the trash. Victim Murphy stated she became distracted by a customer and left her phone on the cart just a few feet away while momentarily dealing with the customer. Victim Murphy stated she was behind the photo counter while dealing with the customer and could see the suspect standing on the other side of the photo counter just a few feet away. The suspect was standing directly in front of the cart where Victim Murphy's phone was sitting on. Victim Murphy stated while dealing with the customer, the suspect interrupted her multiple times, which she believed may have been a distraction technique. Victim Murphy stated after finishing up with the customer, the suspect was gone and so was her phone, a navy blue iPhone 12 Pro Max. Witness Regals, who's a Walgreens manager, stated after hearing that Victim Murphy's phone was missing, she began reviewing surveillance video from within the store. Witness Regal stated while reviewing the surveillance video, she observed the suspect steal Victim Murphy's phone before fleeing the scene on a white bicycle. While Officer DuBois also reviewed the surveillance, observed Victim Murphy set her phone down on a cart before helping the customer at the counter just a few feet away. Officer DuBois observed the suspect come into frame while holding his phone in his left hand and looked. The suspect then placed himself between Victim Murphy and her phone with his back facing Murphy's phone on the table. The suspect continued playing with his left phone, his phone in his left hand while reaching behind himself with his right hand and picking up Victim Murphy's phone. After picking up Victim Murphy's phone at 16:26 hours on the cameras, the suspect left the store and rode away on a white bicycle. Officer Aguilar canvassed a nearby apartment complex, Marion Manor Apartments. As Officer Aguilar was traveling through his apartment complex, he observed the white male wearing red shorts and a black hoodie traveling southbound on a bike towards the Westboro condos. The male was carrying a grocery bag and began walking towards Officer Aguilar's patrol vehicle.
Jeez.
Officer Aguilar asked the male if he was just at Walgreens, and he stated yes while showing Officer Aguilar his bag. This male was identified as defendant Nicholas Salamansi. Defendant Salamansi told Officer Aguilar, "I think I know what you're looking for." As he reached into his left pocket, defendant Salamansi pulled out an iPhone and informed Officer Aguilar that he grabbed it on accident because he has a similar phone. The phone had been shut off, so Officer Aguilar inquired why it had been shut off. Defendant Salamansi stated he shut off the phone to preserve its battery and also so it couldn't be tracked because he intended to return it later. While patting down defendant Salamansi prior to his arrest, Officer Aguilar felt a small container which defendant Salamansi immediately identified as medication he had purchased from Walgreens. Further inspection of this bottle confirmed it contained 28 alprazolam pills and did not have a label on it. On May 14, 2025, myself, Detective Attard, completed an interrogation of defendant Salamansi at the Brownstown Police Department. Defendant Salamansi was advised of his Miranda rights, stated he understood them, and signed the notice of rights form. Defendant Salamansi stated to Detective Attard the same story he had initially provided Officer Aguilar. Detective Attard advised Defendant Salamansi that the incident was captured on camera and obviously identifies him as stealing the Walgreens employee's phone. Defendant Salamansi then admitted that he did steal the Walgreens employee's phone and turned it off to prevent the phone. Correct. Defendant Salamansi stated he was not sure what he was going to do with the phone after he had taken it. Defendant Salamansi indicated that the pill bottle containing alprazolam pills discovered on his person during his arrest were his. Defendant Salamansi stated he bought them from a friend who had purchased them in Mexico, however would not provide this friend's name. Defendant Salamansi stated he did not believe he needed a prescription for the alprazolam pills because one was not required in Mexico apparently. Defendant Salamansi has two prior criminal convictions, one from January 10, 2014 out of 19th District Court for third-degree retail fraud where he pled guilty, and one from September 30th, 2016 out of the Third Circuit Court for misdemeanor controlled substance use where he pled guilty.
Based on sworn testimony, I found the crimes larceny in the building and possession of an analog were committed. There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issue of the complaint warrant. I'm ready for arraignment. Sir, step forward, state your name.
Nicholas Salamasa.
Counsel.
Good afternoon, Judge Attorney Corey Westmoreland, appearing on behalf of Mr. Salamasa.
All right. Does he waive formal reading and stand mute?
That's correct, Your Honor.
I'm going to advise you of your rights, sir. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days of the date of the arraignment. You'll be in front of Judge Hessen. That'll be on May 27th at 9 a.m. You have the right to a preliminary examination within 7 days thereafter, at which time the people have to show as to each count that the crime was committed and that you were the one who probably committed the crime. That is larceny of a building and possession of an analog specifically alprazolam. Do you understand that?
Yes, Your Honor.
Probable cause conference, again, May 27th at 9, preliminary exam June 3rd at 10:45. Mr. Westmoreland, I'll listen to anything you have to say regarding bonds.
Yes, Your Honor. I would like to point out that Mr. Salamasa currently is residing in Brownstown, so he does live locally. He's 33 years old, single male. He's not currently on probation or parole. He has no other pending matters at this time. He's never failed to appear in court for any reason. And after speaking with him at length, he did assure me he would be appearing at all future court dates. He currently is and has been in touch with the guidance center, as he does admit and recognize that he does have a substance abuse problem, and that's his number one goal right now, is to get some
Sir, do you work?
I do not work, sir.
Why not?
I worked over a year ago. I lost my job due to my drug issue. I just recently applied for a job, though, at the gas station right there at Telegraph and West Road, and that looks promising.
All right. Who do you live with on Mahoney Court?
My mother. I live with my mother, and every cop here knows where I stay, so it's not like I'm gonna escape from them. They all know where I live and where I stay at. So unfortunately, but.
What do you want, Detective Petard? Anything you asking for?
Your Honor, he has admitted to me that he does have a drug abuse problem, and I also spoke with his mother that is very concerned about his drug abuse problem, causing him to make bad decisions for himself. We're hoping that he would enroll in some type of assistance.
I already have enrolled. I have an appointment on the 25th at 9:00 a.m. at the guidance center.
Sure. I'll give you your bond. You need to get your life in order. $10,000 personal bond. No contact with the victim, Peyton Murphy. You cannot write, phone, see, text, email, or communicate with her, or have anybody else do any of those things for you on your behalf. You're not to enter 2300 Telegraph in Brownstown. No contact with prosecution witnesses except through your lawyer. No alcohol, no marijuana, no illegal drugs. I want you going to NA at least twice a week. AA at least twice a week. You'll be in front of Judge Hessen May the 27th. You have to go in person, AA, and every time you bring that, every time you go, you have to have the form signed verifying your attendance. Detective Petard will give you one of those. And every time you come to court, you have to bring that form with you. Do you understand that?
Yes, Your Honor.
All right, I wish you well. Good luck. Thank you.
Thank you very much.
Have a nice afternoon, Your Honor.
Thanks, guys.
Thank you.
I got another one here. People against Stephen Tyler Schmidtling, 25B710802. Where'd he go? Who's this?
I think that's a sign on record.
I called Brownstown and I told them we had full sign on record and custody.
Well, where's Crystal Tulas now? She's not going to make me wait here, is she?
I don't know, but.
Call over there again, please.
It's 2 laws, that's what it is?
Yeah. People against Marcus Terrell, McCory, Thomas, 24R, 513, 612 A and B and C. Failed to appear.
He's here. He's been on Zoom for hours. I've been trying to get the attorney to log in.
What attorney? He's got a lawyer?
He's assigned to Mr. Gaith.
Yeah, two lots.
Mr.
Okay, I'll let him know. Thanks, yep. She's gone for the day.
Oh, okay. Well, what's the problem? We'll do it another day, I guess. What happened with Corey Thomas? So she's saying this is Mr. Gase and the gentleman's been here, right, Lisa?
Yeah, he's been on Zoom. I know John told Mason a couple times that he's on Zoom.
I did tell him this morning. He might have forgot about it. I don't even
Is Mr. Collins still here?
I don't even know. Is it a Rocco kid?
Yeah.
They might all left. I don't know.
Jeez. All right. Why don't you bring him in, will you please, Lisa? I'm talking about McCory. People against Marcus, Terrell, Corey, Thomas, 240-513-6128, B, and C. Your name, sir?
Marcus Corey Thomas.
All right, just don't walk around here. Please, just bear with me. Will you stop walking, please?
Yes, sir.
The prosecutor, I think, has already left.
Mason's here.
But the prosecutor's left. So what?
I didn't make it that far.
So I'm gonna have to. I'm so sorry. I'm gonna have to reschedule this.
No.
Let me call him and see something.
What? Hey, Mr. McCrory, guess what?
Yes, sir.
You're not gonna believe it.
What happened?
If you'd have shown up back in 2024, we'd have been done with this a year ago.
I understand.
Right? Right?
I understand.
Okay, so your mistake, your intentional avoidance of the court is a lot worse than a mistake that we made internally because we were trying to help somebody appear by Zoom because you live out of state. So I get it. The good news is you've got a speeding ticket and a no insurance ticket that you can pay before you get back. And that will help you on this other one, I'm quite sure. I'll reschedule this. I'm sorry, I really am. Reschedule, Lisa. I don't know how we're going to do this so this doesn't happen again. We'll reschedule for May the 29th. In what time?
9:15.
At 9:15. That'll give you time to save the money and pay these other tickets, though. Okay?
Yeah, I was just.
In all seriousness, I do apologize. I don't know what happened. Somebody dropped the ball, and it wasn't us. It wasn't the court. It was more like court-appointed lawyers. So I'll have to take care of this on that date. I do apologize. All right. We'll see you then.
Yes, sir. I was trying to see, like, with the tickets. I was, trying to establish like a payment plan for all of it.
You had a payment plan. You created your own payment plan when you haven't shown up here for a year, right? Let's go. Get these tickets paid. I'm serious. You can't do this. Where do you work at?
Right now I work at a plant, a piping plant.
Well, you should be able to pay these before then. You owe $282 on one and $225 on the other. You got 2 more weeks, and you've known about this for 14 months. Okay.
No, sir. I just found out because all the mail was.
I can't hear you. I gotta see you, and I've gotta hear you. I can't look at the sky.
Okay.
Tell me what you said.
Yeah, I was trying to say that all the mail that was being sent to my ex's house, like the mail pertaining this case.
Save your money and get these paid. Do that. And things will work out very easily for you, okay? We'll see you in a few weeks. There's nothing I can do right now. I'm sorry. I really am. Good luck. We'll see you in a couple of weeks and try to save as much as you can, and then we'll talk about it with your lawyer, okay?
Yes, sir.
Thank you.
No problem.
You have a 1:30 show cause.
What's that?
It's a sobriety court. And there's also a new felony coming in.
Well, great. Glad I'm earning my money today. Come on in.
If you could please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
All right, state your name again, please.
Jenny Lou.
All right, you can put your hand down. Ms. Lewis, it's the court's understanding that in the case ending in 0628, that you're going to be pleading to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes.
All right, do you understand what a no contest plea is?
Yes.
All right, two things about it I have to make sure that you understand. The first thing you need to understand is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Mr. Gaddy, the basis for the no contest plea?
I'm sorry, Judge, potential civil liability.
Ms. Liu, to the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Did you want to plead no contest, Ms. Liu, like we discussed?
I thought that's what it was.
Well, no contest is.
So am I
that you're
saying no
not con-
contest?
If that's how you want to plead, yes.
Okay, yes, sir. Can I say no contest?
All right, let's do, you want to do over. All right, so to that charge, how do you plead?
No contest.
There you go. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
You are not. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 1957-23. Any objections to the court having reviewed that report?
No, Your Honor.
None from defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2 in the case ending in 628, and count 1 in that case is dismissed, as well as the case ending in 014. That case is dismissed. This is a victim's rights case, so.
You did, Your Honor.
Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
June 11th at 9 a.m.
June 11th, 2025, 9 a.m. before me. Bond will continue in this matter. Okay?
Thank you, Your Honor.
Thank you, Ms. Liu.
Thank you, Your Honor.
Okay, so on June 11th, what's gonna happen? I'm coming back.
Yes, you'll come back and I'll impose sentence. I can't do it today because the victim has to be contacted in the case. And so I otherwise I would sentence you today. But yeah, you'll come back on the 11th.
All right, Your Honor, thank you.
All right, thank you.
I'll talk to you before then, Ms. Liu.
Okay.
Court calls the case of the People versus Jacob Dorston.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Dorston, who is making his way to the podium, Your Honor.
Your name, sir?
Jacob Dorston.
All right, what are we doing on this case?
Your Honor, Mr. Dorston would like to set this matter for preliminary examination. We have had discussions with the people, but he'd like to set this matter. Discovery is complete to the best of our knowledge.
So he's not requesting the adjournment on the.
Oh, no, Your Honor, that's my fault.
Well, no, that was from last time. I'm sorry.
Oh.
All right. So all discovery is complete.
Yes, Judge.
People have their witnesses available the 27th.
I believe so. The
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Judge.
Bond will continue. I need that.
10 o'clock.
27th, before Judge Freshour. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
All right, thank you.
That wasn't me.
I know.
This time.
This time. All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yeah.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yeah.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 p.m. with Judge Conlon.
July 9, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue.
So that's a pass.
Court does call the case of the people versus Anthony Flanagan.
Joseph and Colin of the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Anthony Flanagan.
Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
All right. You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
We do, Your Honor.
7 for 6.
Your Honor, we
preliminary
acknowledge
examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Wilson.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pre-trial will be set for
June 3rd at 1:30 p.m. with Judge Conlon.
June 3rd, 2025, 1:30, Judge Conlon.
You're all set.
Bond continued. Thank you.
Thank you, Your Honor.
Court does call the case, people versus Corey Craig.
Come in. Okay, I thought he was out in the hallway.
Alexandria.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Corey Craig.
All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
And that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call. I have not received that. Thank you.
All right. And we're saying would you be available on 29th?
Oh, I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Court does call the case of the people versus Haley Gregg. Oh, boy.
Good morning, Your Honor. Great to see you. Christina Costantino appearing with and on behalf of Haley Gregg.
See, you're over there. Your name is?
Haley Gregg.
All right.
Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court. Thank you.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea? Or?
Yeah. And I don't have a report.
I do have a clean copy of the report if I could also present that to the court.
So I'm supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
That would be my fault.
Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
That one's a good question, Judge.
It's $4,000.
That it was. $1,000 on the attempt.
I believe it should be 500.
Yeah, we're rolling along in this.
Sorry, Judge. I had to come along
Pushing home and
mess
I would
everything
blame
up.
both of them all day for this.
So
Not you.
sorry.
You're good. This is not your fault at all.
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge. Very sorry.
What's the maximum? Well, hang on, folks. The maximum penalty on this is going to be. Well. Give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
it says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course.
On the
do more.
principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be
All right.
my understanding. My math is not great, but it seems right.
Is she signed any advice or rights? Well,
Oh, goodness. Judge, I'm sorry.
but let's see. We called one case of Constantino's and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
You decide here.
I have.
Hard to get the
I have no
signature when they're in custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues. I need you to sign this as well.
I'm so mad.
I need you to sign there. Sign.
Okay. All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration. and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge.
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do, Your Honor.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, I do, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct? A question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah. Yeah.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yeah.
And because you believe that you are indeed guilty, or I won't ask you that, never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. To the defense counsel, have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently $5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing. That would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released. We would ask if the court would consider a personal bond. She's also been in touch with Community Mental Health, and she will be working with them upon release.
Response.
Mental health, we would have objection to the lowering bond.
Okay, I will for a bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with Community Mental Health. Okay.
Thank you very much, Judge.
You're good.
Oh, yeah.
All right. Follow through on everything.
I will.
You hear me?
Yes, I will.
All right. Thank you.
Thank you, Judge.
This is Wisconsin. Court does call the case of the people versus Antoine Pitts. Speak French again. Antoine Pitts. Really? So there's a prosecutor on this too?
Jennifer.
What? Is this your case?
Well, the two of us are looking at each other like, who, what? David I. Goldstein appearing on behalf of the defendant. I didn't have this on my calendar for some reason, Judge. Apparently neither did she.
All right.
Your Honor, I received an email from Mr. Pitts last night. Apparently he's having a medical problem. He did send me a medical letter indicating he's been ordered for bed rest and oxygen. I'm trying to find it so I can show it to the prosecutor in the court.
Well, when did that happen? Because I issued a bench warrant for him without bond because he has not done anything at community corrections.
That was within the last couple of days, Your Honor.
So this bench warrant was ordered before then. Back in the earlier part of May, he's not been in contact with them.
Okay, I will, I did see some kind of a bond violation report, Your Honor. And that's why I assumed it wasn't on today because the warrant had been issued, so.
I'll leave the bench warrant outstanding and then he's having a medical issue. You can send it in a recall and I'll look.
Well, I'll get in touch with him and we'll figure out what's going on.
All right.
Thank you.
Thank you. Let's call the case. People versus Devassier Hennings.
Thank you, Richard. Deputy for people.
This will go much smoother. Christina Costantino on behalf of
I do
Mr.
not believe that to be true.
Mr. Headings, can you please state your name for the record?
Devassier Henning.
Thank you.
Judge, this is a date and time set for our PCC. We have just recently, as of yesterday, received some additional discovery that has led me to believe that there is some additional outstanding discovery. So given that, we would be asking for an adjournment of the PCC.
We do have a great sheet.
I do.
Oh.
And
We are prepared.
See, I told you it'd be smoother.
Yeah.
Mr. Hennings is co-defendant. He said Mr. was actually on the 3 p.m. block with Ms. Barnwell. I saw her actually in the courtroom 2 minutes ago, though. So I just wanted to make the court aware that his co-defendant will be here much later today.
All right. June 5th work for you? Well, I can do the 29th. Will that be better? Because
If we could do the 29th, that would be great.
probable cause conference, May 29th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge. Have a good rest of your out of your hair.
You're done?
I'm out of your hair.
Really? You're done. Took up 4 hours. Now you're done. All right. Have a great day. Time I don't get back. Court calls the case. People versus Reno Sabe.
Richard, Deputy for people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, the defendant is not present. He can be on Zoom if necessary, but we had already been notified this matter was going to be dismissed prior to today. I believe that Ms. McDuffie has an order for the court.
I'm trying to make my way over.
Well, is that correct? It's going to be dismissed?
That's right.
No objection?
No, Your Honor.
Case is dismissed. Getting things at the last minute. Is he in Zoom? Mr. Suave, sir, state your name.
Yeah, good morning, Judge Reno Suave.
All right, your case has been dismissed. I'm assuming you don't have any objection to that.
No, sir.
All right. Have a great day, sir. Thank you.
Thank you, Judge. Appreciate it.
Court calls the case, People versus Cedric Johnson.
Your Honor.
Morning, Your Honor. Edward Dukas on behalf of Cedric Johnson.
All right. Your name, sir?
Cedric Johnson.
All right.
At this time, we'd like to set this for a preliminary examination
All right, he does have the bond violation.
for the new case.
Well, is there another case coming?
There's another case that he's got
Pardon?
he has a misdemeanor charge that came through from, that was the bond violation in this case.
This is the one where he had a double contact.
That's correct, Your Honor. There's a misdemeanor count of DV in 1482.
But that's not considered a violation of this one?
No, it is, Your Honor. He was arraigned on that case on 5/12.
We just did an arraignment last week to get this date. Or was it when was our arraignment?
It was on.
The arraignment was on Monday this week. And he got this PCC date to go in front of you.
Right, but there's a bond violation, is what I'm indicating.
If the court has it. I mean, I'm in receipt of understanding that there's a new case that I would anticipate being that bond violation. Because he wasn't.
Well, I don't know that. He was arraigned on a
He also failed.
bond violation.
He failed to show up at the exam.
That case is the bond violation.
Okay. Well, what am I gonna do with the bond violation at this point? I mean,
It's difficult to address if he's got a pending case. And
well, at this point, his bond is revoked in any event, so it's gonna be revoked. You want this set for preliminary examination? Why is this one listed before me? Was this my case? No.
it was previously
set before.
Yes, it was an exam that was set. And
That's what I thought.
He failed
It was
to-
set before me.
That was on 4/29.
yeah, he did turn himself in last Sunday. He had the mix up of the court.
So all discovery is complete.
Yes, Your Honor.
People have their witnesses available. My next date is June 3rd.
Who's our best, Your Honor?
Preliminary examination will be set June 3rd, 2025, 9 a.m. That's before me. All right. Thank you.
Thank you.
Thank you.
Court calls the case of the people versus Areli Benzara Vilches.
Ashley Lonnie for the people.
Good morning, Judge Lawrence H. Margolis, and on behalf of Ms. Barraza Vilches, Ashley Areli, please state your name.
Good morning, Judge. Areli Barraza Vilches.
Okay, what are we doing?
Judge, it's the first, I believe we're waiting on some discovery. I'm asked to adjourn it, and I would defer to the prosecutor as to the time she would like.
Your Honor, there is outstanding discovery, specifically the autopsy, as well as the lab results. So that's going to take a little bit of time. I can't say with any definitive
Understood.
facts how long, but it's going to take at least a few weeks, I would think.
Probable cause conference will be adjourned June 12th,
Maybe people will be heard on bond.
2025, 9 a.m. Yes, that's the bond.
Your Honor, can the court inform us how many times the defendant is testing per day? She's on a sober link. I couldn't quite tell if she got a sober link or a scram.
So she had.
I have her on a location tracking. I think she's on, I have her on a scram.
Excellent. Thank you, Your Honor. Nothing further.
Bond will continue with its conditions. Thank you.
Thank you, Judge.
Court calls the case people versus Danielle Landeman.
Ellie, on behalf of the people, Your Honor.
Carolyn Foster Tucker on behalf of Danielle Lampman. You state your name? Danielle Lampman.
Thank you. Yes. look. But we're going to shut down her potential communication with the alleged victim in this case the best way we can.
All right.
Thank you.
I'm gonna need an order that says that kind of.
Court calls the case, People versus Michael Hill.
Good morning, Your Honor. James Fifelsky on behalf of Michael Hill, who unfortunately is not here. I just went out to the hallway to check to see if he was present and did not see him. I've called him a couple of times and wasn't able to leave a voicemail message. So just for the sake of the record, I would ask for one brief adjournment.
He already has the bench worn out.
Okay.
So his failure to appear, I'm just gonna leave the bench worn out.
What, is there a bond set on that or just a?
He has no bond.
No bond. Okay. Thank you, Your Honor.
Court does call the case, People versus Angelica Towers.
And is it on behalf of the people, Your Honor?
Groups for Angelica Towers.
Angelica.
Thank you. All right, what are we doing?
Your Honor, there's some negotiation and I'm asking for an adjournment today. I'm asking for a short adjournment. And I understand that the bond violation.
Pardon?
Maybe a bond violation as well.
Yes, violation of her no contact order.
That's correct. I have the understanding I was contacted by the complaining witness in this case. I was told that he had spoke to the victim advocate, two of them, and he would like to address the court today.
For what reason?
To allow contact.
That is correct. He is here to request contact.
In light of the bond violation? I'm not gonna do it that way. I mean, I have an alleged bond violation. Now I have somebody coming through wanting contact. I don't. What I will do, probable cause conference, I will adjourn to May 29th, 2025, 9 a.m. I will also set it for a bond violation hearing at that time. And then I'll hear from the parties. So actually that's, on that day. For probable cause and the bond violation here. Bond at this time will continue. Thank you. Court does call the case, People versus Julia Sosinski.
Ashley for the people.
Your Honor. James Fifelsky on behalf of Ms. Szynski. State your name for the record, please.
Julia Szynski.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of heroin, a 1-year misdemeanor. Upon her successful plea to that charge, the felony would be dismissed. There's also the agreement between the parties of no 7411, delay, or deferred.
That's correct, Your Honor.
That's correct, Your Honor.
Let's have her sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes, I do.
State your name.
Julia Szynski.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of are part of a trial, you understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily,
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 3rd, 2019, location of US 23 near North Territorial Road, Northfield Township, Washtenaw County, State of Michigan. Did you have heroin in your possession?
Yes, Your Honor.
Did you use it?
Yes, Your Honor.
And did you know what you were using was heroin?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before that's fine.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
June 16th at 9 a.m. for Judge Freshour.
June 16th, 2025, 9 a.m. before Judge Freshour. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case People versus Larzell, Washington.
Good morning, Edward Lucas on behalf of Larzell, Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within the week. Like if we could have a 1-week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Marquis Fab.
Oh, excuse me, sir.
Yeah.
Can I please have a word? With all due respect.
I think Mr. Washington would like to address Bond.
Excuse me,
Go ahead.
How you doing, Your Honor? My name is Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
Go ahead. Thank you, sir. What happened was I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to.
Who didn't do their job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was.
And then how'd you come into custody?
Oh, I came into custody? What, trying to be a good Samaritan. Some woman was being stalked and they figured out what my name was. And I totally forgot. I really didn't know what court date it was. And I was disciplined for the first, and in the discipline, well, not necessarily discipline, you allowed it to, override until they took care of their situation, but it's not my fault.
So who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mm-hmm.
Okay, I get here today, the assessment not taken care of. Right?
You just want them to speed up the process.
No,
I think
not them. It's not his fault. He's a judge.
Mm-hmm.
They
Thank you. That's right. Nothing is my fault.
No, yes, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work the carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're gonna keep you in.
All right, man, you're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so does you understand before you make that final decision about firing him? Well, it wouldn't have mattered whether you spoke or he spoke. I'm denying your motion. I've already heard it.
Well, I don't know. Why are you denying the motion? And what's so funny?
Because
wow,
because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes,
that's how we got you back.
And the
so I'm not releasing you
right,
now.
The magistrate.
Okay, so
did not release me, and then
that's right.
You didn't release me. Because
that's right.
Wait for assessment. Am I correct?
And I haven't had the assessment yet.
Exactly. So is it my fault you haven't had the assessment? Is it your fault?
My fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. You do agree?
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank you.
Thank you, Ron.
Well, keep talking. Why are you up here at my podium? Why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called Mr. Babb, Marquise Babb.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, People State of Michigan versus Babb.
And then on behalf of the people, Your Honor.
Stephanie Cannon, on behalf of Mr. Babb, should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there. So what had happened?
Marquise Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're just setting it for a preliminary exam.
What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're gonna call him?
Yep. Yep.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. This is
Great, he got it.
yes, I can relate. This is so you. You're like, what? Oh, uh-oh. Mr. Babb?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Babb?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time, Your Honor.
I won't be here to witness it. It's going to somebody else. All right. All discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Court calls case of the people versus Marvin Sullivan.
Andrew Childress appearing on behalf of
James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan.
Thank you. Your Honor, this is a first PCC. I'm asking for an adjournment for discovery and investigation. So I can review discovery with my client, and if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No.
I'm not sure.
They got up to driving without ops on the person.
Maybe a misdemeanor case.
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has here is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant of Mississippi, but we have verified that there is a warrant, there is a warrant for out of Mississippi,
but we don't have the governor's warrant yet.
Correct. And so there is a CCW, Mr. Sullivan has a pending CCW charge now, 8/27/2022. And then the facts of this case have been false, so that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, in 2012. And obviously this case involved possession of firearm and shooting it in the vicinity of a Washington County Sheriff's deputy who was training a canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that it was Mr. Sullivan who was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the file, frankly, the $10,000
That is low. Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, most of the bond reduction is denied. Bond will continue. Thank you.
I'm down. Thank you, Your Honor.
Court does call the case of the people versus Cassandra Beret. Four. Sorry to wake you.
Sorry, I'm so busy. I'm busy probably handling her case. So, Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr. Ms. Bohr, can you please state your name for the record?
Cassandra Emborg.
Court has before it a plea form. Is that what we're doing?
Yes, Your Honor. I have an advisory right before me.
All right. The plea form indicates that the defendant would be pleading to an added count 3 of operating while intoxicated second offense, the 1-year offense. Upon a successful plea of that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
Is that the people's understanding?
Yes, Your Honor.
May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cassandra Bohr.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes, Your Honor.
All right, that is a misdemeanor, punishable by up to 1 year incarceration, a $500 to $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand that the court could also order community service, any rehabilitative services the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today to get you the plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 27, 2022, at the location of US 12 and E Horse Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had drank beer during the day, ate, and then I went to a bar and I had liquor, a couple drinks at the bar. I hadn't drove at all that day other than returning home that night when I got pulled over.
And Your Honor,
Were you stopped by the police or was there an accident?
I actually hit a ditch with my boyfriend's car and yeah,
So there was
police were
an
called to the
accident.
scene. I couldn't get out.
Didn't
of
do
it.
that on purpose, did you?
No, Your Honor.
So there was an accident? Not with
Yes, Your Honor.
beer. All right. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
No, Your Honor. I was taken to the hospital for a blood withdrawal. And then I checked
But,
myself.
but you were taken there in a police car
Well, yes, Your Honor.
right?
Yes,
So you were arrested.
yes,
You weren't free to leave at that point, correct?
correct.
All right. There was a blood draw.
Yes.
All right. What were the results of that blood draw?
Your Honor, we would stipulate to 0.277.
277? Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
Had you previously been convicted of operating while impaired on or about April 18th, 2013 in the 18th District Court and or operating while impaired on or about June 30th, 2014 in the 34th District Court out of Romulus?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 14B District Court. Sentencing in this matter will be
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
You're all set, okay?
Court calls the case of the people versus Kenia Jackson.
Ashley Lonnie for the people.
Mac, appearing on behalf of Ms. Jackson. I don't know if Ms. Jackson is joining us.
Who do you have?
Burmeister. He's pulling on Jackson right now.
Okay,
He's pulling Jackson right now.
okay, thank you.
Good morning, Your Honor.
Their appearance.
Yes, Your Honor. Ashley Lonnie for the people.
Hugo J. McEnroe, appearing on behalf of Ms. Jackson.
Your name, ma'am?
Kania Jackson.
All right, what are we doing?
Your Honor, I've had a brief conversation with the prosecutor. I would ask that you allow both of us to approach the bench or something that I need to inform the court of.
Approach.
Mr. Brooks? Oh, I think he's on, yeah.
Michael Brooks?
There he is.
Need to unmute and state your name, please.
Can you hear me now?
I can hear you now. State your name.
My name is Mr. Michael Brooks.
Thank you.
And Your Honor, we are just requesting a step for examination at this time. All discovery is complete to the best of my knowledge.
People have their witnesses available the 27th.
I'm sorry, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge That's before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case People versus Kyle Burmeister.
And then on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Mr. Burmeister in case ending in 5078, Your Honor.
James Fifelski appearing on behalf of Mr. Burmeister on the case ending in 5028.
Burmeister, can you please state your name for the record? Your Honor, we're just requesting a 3-week adjournment for purposes of him going in inpatient. He's just awaiting a bed right now.
That is correct, Your Honor.
Probable cause conference, June 3rd to June 5th, excuse me. 2025, 9 a.m. Bond will continue.
So I'm just.
The way you heard
that.
I don't know.
All right.
Sit up here, not doing anything. Okay.
Thank you, Your Honor.
Court does call the case of the People versus Winona Harvey.
Jennifer Douglas for people.
Harvey.
Morning, Your Honor. Hannah Mack, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
All right. Ms. Harvey, can you state your name?
No, I can't. I know you got my last name is Michelle. Who are you? Who are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, so maybe she doesn't want to be addressed as a Mrs.
Understood.
No, I know miss. People don't miss me or nothing. I'm the Harvey.
Sorry about that.
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come to the
Excuse me, what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said.
Until when?
Which date did you get?
June 5th.
June 5th, you want to see me?
No, I'm gonna see you before then.
Look, I'm not going back. I can't go back in the conference room. That hurt my back a lot. That room you took me and hurt my back a lot.
Okay. I'm going to let you talk to your attorney some other place, okay?
Okay.
Thank you. Shut her, please. Clerk calls the case, People versus John Fulton.
We're ready.
Deputy Chief Public Defender thing on behalf of Mr. Fulton. He's in the lockup, should be on his way out. Your Honor, today is the date and time set for the probable cause conference. I believe that we've adjourned this matter because we're waiting for a mitigation report. That mitigation report is almost complete, so we'd ask for one more adjournment. We've got the final piece of information we need.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you. Gotcha. Court calls case, People versus Demond Bransford.
Brian Bowling on behalf of the Bransford.
Your name, sir?
Lamar Bransford.
Thank you.
I have a green sheet, Judge.
All right. Requesting an adjournment.
I am, Judge.
Will be adjourned to May 29th, 2025, 9 a.m. Bond continued.
Your Honor, may I address one issue of bond? Would the court allow an order for him to be released to treatment if it becomes available?
If I get that order, I will sign off.
I will submit it. Thank you, Judge.
Thank you. Court calls the case, People versus Alan Franklin.
And is that not you, Your Honor?
Good.
There he is.
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Alan Franklin.
Your name, sir?
Alan Franklin Jr.
Thank you. All right, what are we doing?
Your Honor, I was going to ask for an adjournment. I was just received this case Tuesday. I do not have discovery yet. I know I can't fill out a green sheet from Zoom, but I apologize, but just 2 weeks, Judge.
Turn this out May 29th, 2025, 9 a.m. or if your invite indicates, bond will continue. All right,
Thank you, Your Honor.
I'm sorry, I still will wear this tether or the
Pardon?
GPS. I still wear the GPS.
You still have to have the GPS on.
Okay, that's all I need to know. Thank you.
Okay, thank you. Court calls the case of the People versus Rick Artuso.
And good morning, Your Honor. Assistant Public Defender Timothy Carey, on behalf of Mr. Artuso, who is approaching. Mr. Artuso, state your name for the record, please.
Rick Artuso.
Thank you.
Your Honor, I do have a green sheet. We're asking for an adjournment. We're currently in negotiations with the people. I would like to also address bond, please.
Matter will be adjourned May 29th, 2025. 9 a.m. Yes.
Your Honor, in regards to bond, we're asking Mr. Artuso, well, Mr. Burgess is on one of his matters. I apologize.
Okay. Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso. That's the other matter.
All right.
So, Your Honor, in my matter, Mr. Artuso has $1,000 10% bond that was set. He does have a cash or surety bond in Mr. Burgess's matter. Mr. Artuso, it seems as if he went into bench warrant status on Mr. Burgess's matter because he failed to appear to court. He did indicate that he came to court on that date, but he was under the impression his court date was set for 2:00. When he did come, he stated he was here until the building closed and he left. Unfortunately, at that time, our office was not on his case, so he didn't call us. I'm unaware of his communications or if he was able to communicate with Mr. Burgess. So there was no opportunity to have a bench warrant recall.
So how do you come back into custody?
You said you were just in a car that was pulled over.
Yes, I got pulled over. But
So he was arrested on the bench warrant, Your Honor. There are no new charges.
So why didn't he come back to court?
I did ask him that as well.
Okay, and what was the answer?
He did not have an explanation, Your Honor.
Okay.
It was
Go ahead, I'm listening.
He did not have an explanation as to why he did not come back to the court, why he did not, contact the court to let them know that he tried to come. I did explain to him in the future, if he's got any issues with his court dates, that the clerk's office is right there at the front, that all he needs to do is speak with them and they'll advise him properly. The issue that we're having is, in our case, the resolution that we're seeking to reach would require that he pay some restitution up front. Unfortunately, with him being in custody, Judge, he will not be able to do that. He is hopeful that the court would consider giving him a PR bond. I understand if a GPS tether is necessary to ensure his return to court. He has very minimal criminal history, to my understanding as well, but I'd like to see if he could get out so he could raise some money and pay off this restitution so we could get a resolution.
Response from the people.
I would leave it up to your discussion.
If he doesn't appear, doesn't come back, it's got to be picked up. It's going to sit until we can get it resolved. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor. What do you need to say?
I was gonna ask you, Your Honor,
worst comes worst, I know I could, it's Thursday, I'm scheduled to be married on Sunday, I could come in Monday and I could pay restitution, whatever it takes to pay. Scheduled to be what? Married this Sunday.
That is true, Your Honor. He did inform us of that. I don't know if his fiance and his mother are here, but prior to his being picked up, I think he was scheduled to be getting married this Sunday.
I'm not gonna use that as a basis to. I mean, the problem is that you should have come back down to the court. If you waited here all day, you should have come to the court at some point, but we had to pick you up, bring you in. I'm not doing that again. Thank you.
Thank you, Your Honor.
Why? Why, I guess. You just. Sometimes yeah, stop. All right, never mind. Court is on the case of me versus James Clark.
Good morning, Your Honor. Andra Sabri requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Chinazai Kiri Akinruli, representing client Kyle Clark, who is present in person today.
Is Akinruli the one that's supervising you?
That's correct, Your Honor.
How's that going?
It's going very well.
Is it?
Yes.
You don't know a whole lot, so you don't know, right? Never mind. Permission to practice is.
Thank you, Your Honor. Mr. Clerk, please state your first and last name for the record.
Chen Clerk. Thank you, sir. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for a preliminary examination.
All right, all discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 27th.
We'll do our best, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That will be before Judge Freshour. And we'll continue. Thank you, Mr. Clark.
Thank you, Your Honor.
The intern that just appeared, could you just get your last name over to my staff? Appreciate it. Court does call the case of the people of the state of Michigan versus Jeffrey Murphy.
Good morning.
Ray.
Good morning, Your Honor. May I please record David Burgess on behalf of Mr. Murphy.
Marie Tanha, AKA the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just. All right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting an exam be held.
No. People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right, so these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yeah, yes, I will, Your Honor. I'm well aware of what Ms. Tenna will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor, so.
All right, very good. Okay. And with the people
That's a good date, Your Honor.
that will work,
Thank you, Your Honor.
preliminary examination in person, May 27th,
Have a good day.
2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. Can we recall that previous case? Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay. I guess, can we get him back?
I agree with your defendant if it feels appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call you on it.
Okay, so when he appeared, we'll get him back out at some point.
I'm in the
Can I have-
court. I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark.
For people.
Your Honor, I'd ask the court for a brief adjournment in this matter. We're still talking with the prosecutor in hopes of a resolution.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond continue.
Thank you. I'll give you a call, Mr. Clark.
Thank you, Ms.
All right. Take care.
Court calls the case people versus Scott Jenks.
Yeah, then on behalf of the people, Your Honor, Stephanie Can on behalf of Mr. Jinx.
Jinx it.
I didn't. That's not him.
What's up with Cannon's clients?
It's Thursday, Your Honor, so the good news is I do have a plea in this matter, which I can hand to the court and the plea form.
Back there. Who do they have?
They were bringing back the other gentleman.
This is Jenks.
Stephanie Cannon on behalf of Mr. Jinx. Mr. Jinx, please state your name.
Scott P. Jenks.
I have before me a plea form that indicates that the defendant will be pleading to count 3, the domestic violence, with sentencing under 4A. That's the stated count 3. And defendant will seek alcohol treatment. He will also be pleading to an added count 4 of attempted resisting and obstructing a police officer, a 1-year offense. Upon his successful plea to those 2 charges, count 1 and 2 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
Your Honor, that is my complete full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Scott B. Jenks.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
All right.
Speak up for the court.
Yes, sir.
The first charge is that of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
The second charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, sir.
All right, understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of domestic violence, how do you plead?
Yes, sir.
To the charge of attempted resisting and obstructing an officer, how do you plead?
Yes, sir.
How do you
You gotta
plead?
say guilty.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Can you hear him?
I have a hard time. hearing.
You're, okay, we can get some equipment, so let's do that.
Hold on to it.
Do you need help?
Yes, please. A little bit lower. Okay.
All right, is that better, sir?
Yes, sir.
Okay, so up until that point, you heard everything else that I said.
Yes, sir.
Is that correct? All right. So you understand that by pleading, well, I think I was at the plea, so let's just make sure we have that. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. I'll let you get your glasses. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of these offenses?
Yes, sir.
April 20th, 2025, at the location of 418 North Point Drive, Northfield Township, Washtenaw County, State of Michigan. What did you do involving a Betty Jane Jinks that makes you think that you're guilty?
We got in an argument based off of a family member on her side that was making racial,
Your Honor, may I have water?
excuse me?
May I?
Go ahead.
You got in an argument with your wife
Yes, sir.
and you guys were married, living together?
Yes,
This was at the family home?
yes,
And during that argument, did you push her onto the couch?
yes, yes, ma'am.
Ultimately, the police were called?
Yes, ma'am.
And when the police were called, they attempted to arrest you and you pulled your hands back such that they had a hard time arresting you?
Yes, yes, ma'am.
Your Honor, I do believe that's sufficient basis for the plea.
All right. And you didn't have her permission to push her down on the couch when you did that, did you?
No, sir. She was pushing me. I was just trying to get her off of me. I didn't shove her real hard.
That kind of slingshotted around.
Yes, yeah. So, but again, you were having an argument
Yes, ma'am.
and you did push her.
Yes,
You
ma'am.
didn't have permission to push her, true?
Yes. Yes, sir.
Yeah, okay, but sir, you do realize that I'm not saying it would be successful, but you may be able to assert self-defense in this matter? I don't want to hear your comment on that. You understand
Yes.
that is a possibility?
Yes, sir.
All right. Do you want an opportunity to discuss that with your attorney? Because as it stands right now, I cannot accept your plea.
Okay. Yes. Yes, sir.
Want some time to do that? All right.
Yes, sir.
So let's take him back and I'll bring it back out later.
Thank you, Your Honor. Give that to Mr. Allen.
And just remind us he needs the equipment when he comes back out.
Thank you, Your Honor.
Court calls the case, People versus Deshaun Clifton.
Stephanie Canna on behalf of Mr. Clifton.
It is. Your name, sir?
Sean Clifton.
Thank you. You're requesting an adjournment.
Yes, sir.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
And I'll call you like.
Court calls the case People versus Richard Johnson, the second.
Hannah Mackey on behalf of Mr. Johnson, who is to my right. Please state your name for the record.
How you doing today, Your Honor? Richard Johnson?
Thank you.
Your Honor, at this time, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th.
We can try our best, but I wanted to make sure the court was aware. Mr. Johnson has 2 other cases that are already set for exam next week. That's a short turnaround, so again, we'll try our best to get our witnesses there, but I didn't know the court wanted to put them all together.
Now, is there a reason they need to be all together?
There's no reason, Your Honor.
So he has 2 set next week.
Yes, Your Honor.
Preliminary examination in person will be. So will the people have their witnesses available the 27th on this case?
We'll try our best.
May 27th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you.
Bond in this matter will continue. Thank you. Calls case People versus Antoine Coleman.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. Coleman, who is present in person today. State your name for the record, sir.
Antoine Coleman.
Your Honor, we are requesting an adjournment.
Why you know what to do? Why just quit interfering until it's necessary? Just leave her alone. Thank you. I feel like you know something. How much time did you want, counsel? Don't look at her.
Your Honor, we are waiting for him to complete his assessment for drug treatment court. So however much time the court sees fit.
See, you did that all on your own. You didn't need, she wouldn't have told you that. She would have started picking numbers. Which court is he waiting on an assessment?
14B, Your Honor.
All right, let's do it this way. Thank you, counsel, for informing me of that. That makes it easy for me. Unlike your supervising attorney, would you? June 5th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Well, we wait a minute, because I don't. Oh, Ms. Tanner's there. Okay, so let me get this guy, and then we'll get him back out. Hold on a second. I got this. No. Or no? Okay, all right. You just tell me, I'll deal with it. Court calls the case People versus Danielle Klimola.
Andrew Childress appearing on behalf of the people. Your Honor.
And Assistant Public Defender, really on behalf of Danielle who's approaching. Danielle, state your name for the record, please.
Danielle Klimola.
Thank you.
Your Honor, I am handing the court a plea form as well as the advice.
We don't get these before. But never mind. Court has before it a plea form that indicates that the defendant will be pleading guilty to the charge of use of cocaine. That's a misdemeanor, 1 year misdemeanor of use of cocaine. Upon her successful plea to that charge, count 1 would be dismissed. There is the further indication that the defendant is to enter the 15th District Court sobriety court.
Your Honor, I don't know if this, Kiriak, bring this up. My understanding is the defendant is under sentence of honor, a year in jail. And there may be an ask.
That is correct.
For modifying that sentence.
Day?
Whenever the court, I don't know how the court would like for us to address it. We
I
can
wouldn't,
come,
but go ahead.
we can submit a motion to that effect.
You have to present a motion
Absolutely.
for that.
And I guess I'll put on the record right now, you have no objection to that and would be fine with the defendant's entry into sobriety program, which she's been screened.
All right. Okay, this is the court's full understanding of the agreement. Is that correct? From Curtis?
That is our understanding as well. Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you must give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Danielle Claymore.
All right. Mary, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
I do.
Understanding, and I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes. Yes,
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're indeed guilty?
Yes.
March 18, 2025, a location on South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
I did, yes.
Had you used it?
Yes,
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Thank you, Your Honor.
Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
June 3rd at 10 a.m. with Judge Alvo.
June 3rd, 2025, 10 a.m. Judge Valvo.
This was also an email from Ms. Johns from the 15th District Court about possibly setting this on Friday. I don't know if the court gets those sentencing dates for 15th on Fridays. I'm sure they could also modify it. Judge Valvo could also set it on a different day. I know the court only gets so many days.
Yeah, I don't have that.
I only have June 3rd.
So we'll just set it down.
Yeah, okay, I'll just set it June
And
3rd.
you're on the actually at 9 a.m.
Oh, it's at 9 a.m. before Judge Valvo. All right, okay. Thank you.
Almost done. Thank you so much, Your Honor.
Court does call the case People versus Elijah Kraft.
Ally's in on behalf of the people, Your Honor.
She's back.
Good morning, Your Honor.
They gave
Student,
you a bunch of cases, didn't they?
yes,
Did they?
not a bunch, a fair amount.
Not a bunch? Who gave them to you? Did she give them to you?
I cannot confirm or deny, but I was assigned. I'm kidding.
Did Acting really give you all these cases? Did she say when she gave them to you, I don't want to do anything today?
No.
Oh, she didn't say that? Okay, I was just checking. All right, go ahead, counsel.
Student attorney Andra Sabri on behalf of Mr. Elijah Kraft, who is present in person with me today, Your Honor. If you could please state your name for the record.
Elijah Kraft.
Thank you, sir.
Your Honor, we respectfully request that these matters be set for a preliminary examination.
All right. And on both of these matters, all your discovery is complete?
To my knowledge.
And would the people have their witnesses available the 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Right. Bond will continue. Thank you, sir. here. Get to it. Court calls the cases of the people versus Dale Miller, 3 cases.
And Maggie on behalf of Mr. Miller, who is approaching. Please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report and we stipulate to findings of Mr. Miller being incompetent but restorable.
They've determined that he's incompetent to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right. All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Martez Dalton.
Anna Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now to court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
No, he came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor. Maybe it ran out of gas.
What?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warn him?
No, Your
And
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was
So
like
it's the
trees.
common
It was
thing.
video. It was just trees going by a window on a bus. I don't know if it was on a bus. But at least they had gave me pictures. Not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city or?
New York. In New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
I've never been on a bus. I know. Don't know why you're trying to fight it. Just say I've never been on a bus. She doesn't even know if it's a slow bus. Court does call the case, people versus Rahman Mohammed.
My client is not on the bus.
Are you calling him, Mackie?
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rahman Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed. Thank you.
Your Honor, today's date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. Also, we'd like to address bond at the.
All right, all discovery is complete.
As far as we know, yeah.
People have their witnesses available the 27th.
We will try our best, Your Honor. I didn't want to let council know Mr. Muhammad has a new warrant in as of just a few days ago. Office received for a fight in the jail apparently, so I'll have that reviewed as soon as possible.
Preliminary examination, May 27th, 2025.
Thank you,
9
Honor.
a.m. That's before Judge Fresh Hour.
Thank you, Honor. As to bond.
Yes.
Your Honor, my client is respectfully requesting that the court allow him a personal recognizance bond. He does have a place to stay. He would stay with his father, Kushir Muhammad. That would be in Banner Street in Detroit, Michigan. He's asking if the court feels that it's necessary, he would agree to wear a tether to ensure that he returns to court.
Response.
Your Honor, I think the underlying case, or the case that was set for exam is a bit older, if I'm not mistaken. I'm not sure how much in custody. I am concerned that while he's been in custody, potentially accumulating assaults and offenses, but I will leave that in discretion of the court. I would request that if he is released, that he is testing, given the nature of this.
And my client will agree to test.
How did he come into custody?
What's your pick?
A traffic stop.
Your Honor, my client tells me that it was a traffic stop.
Oh, Your Honor, maybe approach, please, very quickly.
Approach. Record should reflect, we've had a bench conference in this case. And in considering everything, I'm going to deny the request for change in bond. Bond will continue.
Thank you.
Thank you. I'm trying to get up on this one. Court calls case People versus Aaron Daniels.
And then on behalf of the people, Your Honor.
And I'm Mackie on behalf of Mr. Daniels, who is to my right. Please state your name for the record. And at this time, we'd like to request that this matter for a preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th. Preliminary examination in person will be set for May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Danielle Pressey.
Andrew Childers appearing on behalf of the people. Michael Gaddy, Assistant Public Defender on behalf of Ms. Pressey, who's approaching Judge. Get your name?
Danielle Pressey.
Requesting an adjournment.
Yes, Your Honor, there's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continue.
If I could be heard on bond, Judge?
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of, I think it's set at 150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. she owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is we'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond, like if she would avail herself of any both a scram and a GPS tether if the court thought that that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for disabled mother.
Respond.
The facts of this case involve the defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe was 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out this matter pending given the seriousness.
Yeah, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here. And I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. The court does consider the defendant a risk to public safety. And so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
No, I'll waive notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
Yeah, as long as I have a fair amount of time to respond to the
Court consider hearing it early as well, Judge?
It will. When we receive the motion, Ms. Weidling will be more than happy to give you a date to hear it.
Thank you, Judge.
Court does call the case of the people versus Jordan Dave.
I'm sorry, Judge. I didn't catch the adjourned date. My fault.
29.
Thank you. All right.
Jordan Davis.
Oh, that's you. I'm sorry. Okay.
And then on behalf of the people around.
And Mackie, on behalf of Mr. Davis, who's approaching, please state your name for the record.
Jordan Davis.
Okay. Your Honor, at this time,
No, I'll wait.
we'd like to set this matter for a preliminary examination.
All discovery is complete.
As far as we're aware.
People have their witnesses available to 27.
Yes, Your Honor.
preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Your Honor.
Thank you.
Bond will continue. Thank you. Court recalls case People versus Jeffrey Murphy.
And that's the prosecuting attorney about people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. Sir, you understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr. Burke.
Yes, of course, Your Honor.
Court calls the case, People versus Harold Dennis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Dennis. Mr. Dennis, can you please state your name for the record?
Harold L. Dennis.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of larceny less than $200 to 93 day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is no objection to sentencing under 77(1.1).
That is our understanding of the plea, Your Honor.
I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? You got it.
I do.
State your name.
Harold L. Dennis.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washington County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that,
Did you have an agreement with him?
yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long,
And how long is too long?
a couple years.
Okay.
2 years? Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the purpose of the plea, Your Honor.
So how long were you supposed to have the vehicle?
Well, it wasn't a determined time, but supposedly till I finished.
Till you what?
Till I finished the job.
What job?
You were doing work
I
on the
was
car.
doing work on the car.
Oh, you were doing work on the car. And so then after you did the work on the car, you were supposed to return the car.
Well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
Did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes.
And it's, so that we're really clear, the work that you were supposed to do would not take 2 years to complete, would it?
No,
In fact, it should have been completed well before that 2-year period,
yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
You did some work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after a few adjournments of the PCC.
and it was returned fully finished and in excellent shape.
2 years older.
Which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Having complied with the court rule, would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept a defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m. 10 a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date and time. And that's the location.
Where am I? And
You don't need to sign off on this one. That's just for you to keep for your record so that you know when to go to that court, okay? You can give me a call later. Oh, all right, take care of you.
Build a car in 2 years. Just thinking.
Think about it.
Court calls the case People versus Barrage Scott. Bellinger, don't come up here with anything else like that.
Andrew Childers, on behalf of Eagle.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Barrage Scott. Barrage, state your name, brother.
Barrage Scott.
All right.
How you doing?
How you doing, sir?
I'm okay.
You're doing very well, Your Honor. Your Honor, today is the date and time set for a competency review hearing. I do not believe that the report has been completed at this time. Does the court have?
I do not have a report.
So, Your Honor, we'd ask for an adjournment to see if that report can be.
Let's do this. Has he been interviewed at all yet? Have he come talk to you, Mr. Scott?
From the forensic center, I'm confused.
Yeah,
Yeah, I went to the forensic center.
Okay.
They did a evaluation or something.
yeah.
They took me from the jail.
Jail to
And
the,
then, yeah,
okay, so when did that happen?
like maybe a week or two.
Oh, just about a week.
Yes,
ago.
sir.
Okay, all right. So let's do this. Let's put you out. Still got to get a report, so. I'll put you out. I'll set this hearing date. I'm indicating no report yet, but we'll set it for June 26, 2025.
So they won't be able to do anything until then.
Okay, that's fine. I understand.
How you feel?
Yeah, but I'll set. Which ones? They're both gonna be.
Yeah.
No, she already had it. She passed acting something.
Okay, so we don't.
I'll just adjourn your probable cause to that same date of 26. I can't go ahead on that case anyway. Whether there's, I technically don't have a comp referral on the other matter, Mr. Brown.
Thank you.
I don't have a comp referral on the larceny of building case.
Oh, you
I do on the armed robbery case, but I can't do anything on that case with that other one pending anyway, but.
Right,
just
right.
so you
So,
know.
okay, we can do an order to match that one. Your Honor, what is my client's bond on this case?
On which case? On the larceny case, his bond is set at 1,000 cash or 10%. On the armed robbery case, his bond. Don't. Yeah, what do you have his bond on there? I think it's denied.
No, we would ask that the court do set a bond in this case. He does have very strong family support, as he has always had. Yes. They are pressing. We're asking that some bond be set for him.
Well, I think his bond got revoked on he was on bond on another case when this happened. So I'm not sure if he'd be entitled to have a bond in any respect because I released him and 8 days later, this case happened.
Okay.
So I'm going to decline to change his bond at this time. Let's get the report back and see where he is.
Report back.
So bond on these matters will continue.
Oh, yeah, absolutely. Absolutely.
All right. Thank you, Mr. Scott.
You're welcome.
No. Court calls the case, People versus John Fleming.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. John Fleming, who is present with me in court today. Record, sir.
John Fleming.
Where are the rest of his pants?
Hoping I'm going to work after this.
Your Honor, we
You'll
are,
talk to him about that afterwards.
will do, Your Honor.
Thank you.
You got a workload today, don't you?
Your Honor, we are requesting an adjournment.
Your Honor, we need a protective order in this case. There's a forensic interview of the child victim that I watched.
Okay.
I have received the protective order, Your Honor. I was just going over it. I'll submit it to the court. Yes.
All right. So probable cause conference, I'll adjourn to May 29, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thanks, sir.
Thank you. Calls case People versus Rashad Shafi.
Commissioner Middleton for the people.
Morning, Your Honor. Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Shafi. And I do apologize, Your Honor, but maybe approach on this one.
What would a day be without Yagi approaching? Come on. Anything. Go ahead.
Can you see me for the record, please?
Jamie Good.
Thank you.
Your Honor, this is the first PCC on this matter. We are going to be asking for an adjournment to continue plea negotiations.
Do I have a green form?
Yes.
Probable cause conference will be May 29th, 2025. Bond continued. Thank you.
Thank you.
Thank you.
Let's call the case People versus D'Angelo Simmons.
Good morning, Honorary Counsel, Assistant Public Defender.
I read in that Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. D'Angelo Simmons, who approaches from the lockup. Under today's date and time set for a competency review hearing, does the court have an updated report?
My most updated report is from April 8th. Dated April 8th, received by us April 14th.
And have, okay.
Double checking, but I believe yes, that's the last one I have.
That's the last report. I don't know why this wasn't said earlier. Or moved out once we got that report.
May I have my client state his name for the record?
Yes.
D'Angelo Simmons.
All right. Well, they would do a review from April 8th. That'll be about July something. So I'll just indicate at this point, I don't have a report. I'll set it out basically at 90 days from the date of this report. So hopefully we'll have something. What's my closest date to July 8th?
July 17th.
All right. No, that's fine. That's a Thursday.
Yes.
I'll set that out to July 17th, 2025, 9 a.m. If we do get a report, this one should have been moved up itself, but if we do get a report, we'll move the date up. All right.
Thank you, Anna.
Thank you. Court does call the case People versus Douglas Hill. Thank you, sir.
On behalf of Mr. Hill.
Got a problem. All right.
We pass it.
Thank you. Yes.
You're good. They gotta cover your butt. You don't want to see it.
Okay.
Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's
That's true.
correction stuff.
No, oh, yes, they rescheduled my appointment for Monday at 9:30 with the Brown guy for the outpatient program.
Yeah.
That, yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet, that's why I assumed that, I don't know how long it takes to leave. my
You're
system.
still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what, if you're telling me you're not, I'm gonna take you back, I'll call over, get levels, and then we'll see exactly what's happening.
So I gotta.
You want me to do that?
So I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff, I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. They probably don't have anybody right there then. They do? Okay. Court does call the case, People versus Romeo Serba. Oh, 2 in a row.
Chairman Adish, on behalf of Mr. Serba, who is approaching.
Your name, sir?
Romeo Serba.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Serbo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother, who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no mistests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15
No,
minutes.
I'm talking about, I got that, but his April 24th report from community corrections.
I don't I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April,
the report that I have, the last test on there that was missed was the 23rd of April. Let me look.
right, but do you have, there should be a bond violation report from April 20, that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay.
Okay.
Go ahead.
Yes. Again, as 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So,
Any response?
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and an A&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision, Oakland County Circuit Court on a similar charge that also falls within the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to tell him that I did ask when I realized it was going to be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted a tether in the first place. And
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
And his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
I will modify his bond, although he may not be entitled to a $25,000 personal recognizance bond, but he needs to be on a scram tether prior to release.
Thank you, Your Honor.
And I've set this over to the 29th.
Thank you, Your Honor.
Thank you.
Thank you.
Case People versus Sherry Hughes.
Nick Gabriel, Deputy for the People. Morning, Your Honor, Mike Gaddy, Assistant Public Defender on behalf of Ms. Hughes, who's not here. Judge, I did submit a green form. I did receive a call from Ms. Hughes' mom yesterday stating that she was at St. Joe's psych ER, I got a call around 8:30 saying they're waiting to be discharged. And I don't think she's in a position to actually be still going to court. Today, I'd ask the court to excuse her presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Getty, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Thank you. Court calls the case of the people versus, you said lot. It's LaDonta Skinner. I don't know why they have it this one.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Skinner, who approaches the podium. Skinner, please state your name for the record.
LaDonta Skinner.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
Both matters.
Yes, please.
Discovery is complete.
Yes, to the best of our knowledge, discovery is complete.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge.
27.
Continue.
Okay, Your Honor, what does the court show as the bonds in these matters?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing.
10%. Both are 10%, Your Honor. Both are 10% allowed.
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
There you go. Somewhere. I don't care about his last one went way back up. Courthouse case people versus Joel Stevens.
Jennifer Douglas, people.
With that, on behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge
Washington.
Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Court does call the case people versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Childers appearing on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates a defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. And it is okay for him to seek hideout in the case. That's the agreement of the parties. It's court understanding.
That is our understanding, Your Honor. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to $1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
Yes. And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading, you will not have a trial? Okay.
Yes, Your Honor.
Did you sign an advice of rights form?
Yes, Your Honor.
All right. Approach. Yes. Signed an advice of rights form. You have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On between the dates of January 22nd, 2024 and January 31st, 2024, at the location of Eastern Eateries on the EMU campus, Eastern Michigan, Washtenaw County, state of Michigan, what do you do that makes you think that you?
Yes, what did you do? No, we're talking.
I used cars without permission, Your Honor. So,
what kinds of cars?
I had used one card without their permission
To get food?
to order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so you did that. And in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was.
I'd be asking the court to take your plea.
To the higher charge for the. All right, and the court can do that. And you didn't have anybody's permission to be using these cards?
Correct, Your Honor.
All right. All right. Counsel, have I complied with the court rule?
Defense is satisfied, Your
Honor. Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
May 28th, Judge Barr at 10 a.m.
May 28, 2025. What time? Time?
10 a.m.
10 a.m. before Judge Barr.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else.
Your Honor, my client has, originally he was not incarcerated. The court put him on, I believe he missed the court date. I think he had taken a trip, a family trip. He had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went.
Yes.
So as a result, the court put him in. We're asking that now that he's pled to the misdemeanor, this is a property offense. My client is scheduled to start his classes on May 19th. We'd ask that his bond be reinstated. He'd be allowed to be released from incarceration at this time.
So is he gonna be at EMU?
Macomb Community College.
Okay, so how do I know that he's gonna get back here?
Oh, he'll make it back.
Huh?
He'll make it back. He has not enjoyed his time in the Washington County Jail.
Okay, so how did he come into custody?
I turned myself in, Your Honor.
You turned yourself in where? Here?
Yeah.
So he knows how to make it back here, Your Honor.
Any response from the people?
No, I would agree. I believe the defendant appeared in front of you back on May 1st and he was free there.
Got it. That's what okay. Do you know the importance of showing up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown is right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond.
Thank you.
Thank you.